Council Advanced Manufacturing Innovation District South Compulsory Purchase Order 2023. It's required to be held following objections by the Barney Group and Taylor and Fraser Limited to the acquisition of Plot 37, of which they are owners and occupiers respectively. And obviously I see Mr McMurray and Mr Davison, who are representing the Acquiring Authority, Renfrewshire Council, and the objectors respectively. First point, I shared with parties yesterday a document with hyperlinks to a document list with hyperlinks to the various documents, inquiry documents. So I don't suppose anyone's got any comments on that, but if you want to comment on that, maybe do now. Okay, good. Well, hopefully that's helpful. Just to run through the shape of today, at the pre-inquiry meeting, we discussed the procedure. And so the procedure today will be as follows. So the council will lead its witnesses first. For each witness, the process will be as follows. The witness will read their summary recognition, or their recognition in the case of the objectors. The council's advocate, well, the council's advocate will may ask open questions of the witness either during the reading of the recognition or following it. And that's called examination in chief of the witness. There will be an opportunity for the objector's advocate to cross-examine the council's witness on matters relating to the objector's case. And then following cross-examination, in case the council, Mr McMurray, will have the opportunity to re-examine the witness on matters that have arisen during cross-examination. And again, open questions should generally be used in re-examination. I may have questions for the witnesses myself, which I would usually ask after cross-examination, though it may be that I will want to ask questions at other stages with permission of parties. And all questions, of course, that are asked should be relevant and should be repetitive and shouldn't be hectoring. I'm sure no one will want to hector. And then, of course, that's the council's process, same process for the objectors' witnesses, though with these differences. Obviously, Mr Davison is both representing the objectors and acting as a witness, so he won't be able to cross-examine, he won't be able to examine himself in chief. So instead, he will have an opportunity to make a statement on matters arising from the council's written evidence, on which he can also be cross-examined. There'll be no opportunity for re-examination of Mr Davison, as we agreed at the pre-inquiry meeting. After both parties' cases have been completed, there'll be an opportunity for parties to make any motions they wish to make about the expenses of the inquiry, and I'll then close the oral part of the inquiry, and parties will thereafter make written closing submissions in respect of the evidence I've heard. In the pre-inquiry meeting, we agreed that objectors would submit closing submissions 2 working days after the inquiry, and the council would submit 2 working days after that. We can review that at the end of the inquiry if those arrangements are still suitable. And as regards today, I propose that we have a 15-minute break, roughly around 11:15, at a time that's suitable, and stop for lunch about for about an hour at 1 o'clock, and resume about 2, and then run till 4 p.m., possibly with a short break around 3 p.m. So obviously, yeah, the breaks will be taken at convenient times, so those are just rough times. And of course, if anyone's feeling uncomfortable at any stage and feels the need of a break, we can just tell me, and we'll do that. So okay, that's the shape of business today. There's a couple of items of business before we crack on. The first is, has a time been agreed for Mr Taylor to give his evidence? I believe Mr Taylor was wanting to give it evidence at a specific time.
No, Mr Taylor, sorry to speak for Mr Taylor, correct me please, but
you should be doing something.
If the event doesn't go on, it goes on for 2 days. Mr Taylor didn't want to be here for 2 days, as long as he's aware of when he's needed and he can step in at short notice. Would that be right, Mr Taylor?
I'll try and watch as much as I possibly can for obvious reasons.
Hmm.
And but if I know that the objectors come last, so to speak, so if it's possibly this afternoon, well, you'll need me. That's fine.
Okay. Well, if we don't get around to your evidence this afternoon, I mean, should we say Mr. McMurray, Mr. Davison, first thing tomorrow morning, and you know, it's up to you to decide what order you lead your witnesses in, but perhaps we can agree a specific time. Mr. McMurray.
Yes, sir. I think we've had an exchange of emails, Mr. Davison and I, around this, and I think what we suggested, what we do is keep an eye on it and just ring it, essentially, just to see if we can have a better idea of progress, essentially, as we went on, so that Mr. Taylor could have advanced notice of when he might be required. But if we don't get on, I have no objection to dealing with Mr. Taylor's evidence first thing tomorrow morning.
Okay. Your sound quality is a little poor. Is the way, Mr. McMurray, is the way you can come a little bit closer to the microphone? I'm just hearing it a little bit echoey.
It's our last.
That's great. Thanks very much. So the arrangement is that we'll simply monitor matters and decide when, you know, if there's a need to decide for Mr. Taylor's evidence will be taken. We'll decide at that, in the course of today. Is that what I was to understand?
Essentially, sorry, yeah, that's all very discussed.
Okay, as long as that's convenient for everyone, that's fine. Good. Okay. The second issue was a couple of new documents were submitted by the council last night. Have the objectors seen those?
Yes, I've seen. Yeah, thank you.
Okay. So does the council want to explain what these are, or why these are relevant, why they're submitted now?
Yes, sorry. The documents arose out of just some, I suppose, attempts by the council to try and resolve matters between the parties and the objectors' statements around the need for additional land, and therefore the council has basically taken some time to try to see if they can find additional land elsewhere that might help alleviate the objectors' concerns, and that essentially resulted in the proposal that was made to the objectors on Friday, which set out both a drawing identifying the land and also an explanation of how each area will eventually be used. I understand Mr. Taylor was perhaps on holiday last week or something towards the end of the week, so I had trying to do that stuff or the launching.
So I'm just missing that last bit of your sound. If you could maybe put the mic in front of you rather than behind you.
Just maybe I might need to unplug and move things around a bit. Sorry.
Okay.
Yeah.
It's still on.
Sorry, is that better?
That sounds a lot better. Yes, thank you very much. Yes.
Apologies for that.
No, not at all. Right. So with that explanation, Mr. Davison, are you content that this should be accepted as a document?
Audit, or do you have any initial views yourself?
Well, I can give you a review really now.
Oh, no, don't
Basically-
do it now, Mr. Taylor. Don't do it now.
No,
In your evidence, in your evidence.
Okay,
So perhaps the best thing to do is to leave it till Mr. Taylor gives his evidence.
Thank you.
And you
Thank
can
you.
respond on the document. So we can accept the document on the basis that Mr. Taylor is able to respond to it without unfairness. Okay. Right. Good. So should we just make it? We'll give it a document reference just to add it to the system. So I suppose it must be Renfrewshire Council document 10, or is everyone happy with that?
Sorry, I believe it might be Renfrewshire Council 11.
Oh, 11 is it? Oh, I'm sorry. Am I missing something? Okay.
I have Renfrewshire Council 10 at the moment as a letter to Taylor and Fraser around public engagement.
Right. Okay. We need to check what I've done with that. Okay. Right.
I'm not sure I'm expecting to refer to it, so, but yeah. But,
Right.
or yeah, I think it's Renfrewshire Council 11.
Okay. Okay. Renfrew Council document 11. Okay. So with that, I think we can ask the council to, unless there's any other matters to raise at this stage. No, we can ask the council to commence their case. Mr. McMurray.
Thank you, sir. Yes, we have the first witness for the council is Ms. Barbara Walker, who is in another room in our office, and you can see her on camera now, sir. Good morning, Ms. Walker.
Good morning. Can you hear me okay?
Yeah, nice and clear.
I can.
Yeah, good. I moved the microphone up.
Thank you. Ms. Walker, if I could ask you just initially to read your summary of recognition, but in front of you, there will be one point I may make as you go through the summary of recognition, and a few short questions at the end. If that's okay, but if you could read your summary of recognition to begin with.
Okay, thank you. My name's Barbara Walker. I've got a BSc Honours in Civil Engineering. I have an LLB and an LLM in Construction Law, and I've got a diploma in Legal Practice. I'm employed by Renfrewshire Council as a Head of Service. My job title is City Deal and Infrastructure Programme Director, and I lead a multidisciplinary projects team which delivers major complex infrastructure projects on behalf of the Council. As a team, we've completed a CPO process 3 times in the last few years successfully. I've had personal involvement in discussions and negotiations with affected parties and been involved in completion of voluntary legal agreements for a wide range of different parties with different interests, complexities and sizes. We were able to successfully negotiate and agree reasonable terms with all these parties, and any objections were removed. The project, the Advanced Manufacturing Innovation District Scotland, AMIDS South project, forms a critical part of the Council's place strategy, and it links into our investment in cultural infrastructure in Paisley Town Centre, schools and housing, as well as the City Deal projects and the investment in new jobs for our residents at the AMIDS. The AMIDS is a Scottish and UK government priority, and we're expecting investment in jobs and creation of up to 10,000 new high-quality jobs, thereby providing new opportunities to our local and city region residents and businesses. It's likely that AMIDS will be awarded investment zone status and a tax site status in the Chancellor's Autumn Statement, further strengthening the UK and Scottish Government's commitment to this site and further demonstrating the need for AMID South to provide crucial connectivity. Aligned to this, we've invested over 100 million in our town centre venues, including a new world-class museum, which will open in 2025. The council is focused on regenerating Paisley Town Centre away from retail and aims to provide other reasons for residents and visitors to the town centre. AMID South provides the critical missing link between these two areas of major investment. The East-West Link Road, which is part of the project, will also provide access for buses, staff and pupils for the new Paisley Grammar Community Campus, another strategically important project for the council. The project significantly improves connectivity for the numerous local businesses in the area, including to Taylor and Fraser Limited and Barney Group, the objectors' business premises. By providing the improved access, including for active travel, the east-west connectivity and the bridge over the river means that they will no longer have to access through the congested one-way system, thereby making significant savings on time and fuel costs, as well as enjoying a much improved public realm, which will have a consequent increase in value of land and premises. The project has been funded through the UK Government's Round 1 Levelling Up Fund, which I'll call LUF, and was awarded £38 million. It received the third highest award in the whole of the UK and the highest award in the whole of Scotland. This was due to the strong business case underpinning the need for this scheme and the benefits it will bring to Renfrewshire and surrounding areas, further enhanced due to the benefits and linkages between the wider investment in Paisley and the surrounding areas, including the thousands of new jobs anticipated for AMIDs. The LUF will provide 90% of the funding for the project, and there's a 10% match funding condition for which the council sought board approval in 2019. There's a condition in the LUF funding agreement that prohibits us from advance purchase of land. It says quite specifically it cannot be used for advance purchase of land. We could go to a council board to seek approval to enter into voluntary conditional missives if anyone wanted this option. To date, no interested parties have requested this other than the objectors, who have subsequently confirmed they're not in a position to provide a full claim at this stage. We require to award a contract before March 2026 in terms of the LUF funding. Note this has recently been extended from March 25, and so we would not expect any further extensions. It would not therefore be possible to complete the project if CPO was not granted. I don't believe there is a viable alternative route for the project. Extensive studies were carried out by our external technical consultants, all in accordance with the relevant standards, and this route provides the best possible option. Additionally, the design has already been amended to impact as little of the objector's yard as possible at significant cost to the project. There have been various technical meetings with the objectors and the team, all reported back to me what they described as perfectly amicable interactions with Mr. Taylor. I haven't personally met with the owners, and that's something that is more appropriate to leave to the technical team. And I put in an NB that I met with Mr. Taylor at the reporter's site visit on the 15th of August. I'm available in the event of any particular issues or escalation which has not been required. There's a file note from Norman Yardley showing that they discussed business operations, as this includes information on, for example, the number of staff working there and the yard information. There's also a file note from Mr. Taylor after such a meeting confirming that Mr. Taylor was concerned when he realised how much of his yard was going to be required for the CPO, and there were discussions about that between Norman Yardley and Mr. Taylor. We keep a log, and we've made contact with every impacted interest. Norman Yardley, Victor Suarez and Margaret Law have, between them, met with all impacted interests. We have no other objections. On 21st of September 2023, we formally wrote to all interested parties notifying of the making of the CPO. This notice included links to compulsory purchase in Scotland, guidance for property owners and occupiers. The CPO guidance confirms the rights, and the letter provides relevant council contact details. I haven't engaged personally with the owners, though have had correspondence and one meeting with Mr. Davison, and then I've already updated that about the 15th of August at the reporter's site visit. I have also had numerous meetings with the district valuer and instructed him to meet and discuss / negotiate with Mr. Davison, subject to council governance, and his advice on the compensation due directly with Mr. Davison, which he has done. There's a funding condition which states quite clearly that we can't use the LUF for advance purchase of land, and additionally the council wouldn't purchase part of a yard without knowing if the project was going ahead. That would not make sense to Mr. Taylor or to the council, and we've explained the reasons that we can't acquire land in advance, but that we can enter into conditional missives to acquire the land by agreement if Mr. Taylor was in a position to confirm all his heads of claim and discuss / evidence the same with the district valuer to enable a compensation figure to be reached. Originally, Mr. Taylor had asked about land at Harbour Road, which is currently the public road access to various premises, but which would become redundant after the project was implemented. But Norman Yardley initially thought that we didn't own it and confirmed this to Mr. Taylor. It transpired later that we did own the solum of the current public road, and so we have since confirmed to Mr. Taylor that we'd be happy to transfer this land to him post-scheme. Mr. Taylor has subsequently confirmed it's not suitable. I've instructed the district valuer to go back and speak to Mr. Davison again about what he's actually asking for on behalf of Mr. Taylor, and if these can be quantified and justified, then I can seek appropriate governance. We would be open to entering into a legal agreement conditional on the CPO being confirmed. The process for route selection and options appraisal is something that's very technical, and so we appoint suitably qualified external advisors to complete this. Our consultants, Amy, are experienced in this type of work and have completed the options appraisal. The consultants have followed the required road design criteria to ensure the most efficient route in terms of value for money and benefit is progressed. We rely on our highly experienced consultants to lead us through this process, i.e. they are appointed for their expertise. This will be detailed in Mr. Bathgate and Mr. Suarez's evidence. In relation to the objectors in particular, I'm aware that through design development we did not finalise the design with the optimum route for the project and for budget, as this would have gone straight through their yard area. Instead, this was pulled into a more perpendicular junction designed to limit as far as possible the impact on the yard. There were other design tweaks that were undertaken to minimise impact on other land other than the objector's land. We have offered the Harbour Road land as Excambian. Mr. Taylor had suggested this originally and asked if he could have the land as part settlement. Unfortunately, at that time, Norman Yardley had written to him believing that the council did not own this, although several months later it transpires we did. So the team had gone back to Mr. Taylor on that basis and confirmed that this would be possible. The council had proposed that if Mr. Taylor used it for staff and visitor parking, that we could surface the area, make it secure and build pedestrian steps up to the yard and provide a safe walking route through the yard to the offices. This would obviously free up space currently used in the yard for staff and visitor parking. Mr. Davison, at this point in time, has rejected that as an option. We would be happy to go back and progress this option should Mr. Taylor change his mind. The district valuer views that the objectors will still have a substantial yard after the CPO and that they've not been able to provide anything to date that demonstrates they will be unable to operate their business with the reduced yard area, though discussions on this are ongoing between the district valuer and the objectors in an effort to understand their requirements and reach a resolution.
And Walker, just at that point there, you said that discussions are ongoing with the district valuer. Are you able to confirm whether the position remains the same as you set out there?
The position remains substantially the same, but after the district valuer visited the site on the 15th of August, he has flagged that there will be more constraints on the business during the construction contract or construction period if the temporary access is taken up by the contractor. So on that basis, we have then gone back and had another look at pockets of land that could be used to help with this and to take cars and visitors perhaps out the yard space to maximise the area that would be available during the construction operations.
And am I right in saying that that's the RC11 document is essentially the product of that?
Yes.
Thank you, Ms. Walker. Please continue.
Okay. Mr. Davison had provided us with a location of a potential second yard that Mr. Taylor could potentially lease and stated that the council will require to meet the cost, whatever it will be. I have explained an uncapped sum is not something I would be able to obtain a board approval for. I agreed that the council would pay £1,000 for Mr. Taylor to obtain a tender for the works that need done. We will then have another discussion with Mr. Davison about the options in this regard, obviously bearing in mind that the need for a second yard has not been demonstrated to the district valuer. The whole project is dependent on this order being made, and no part of the project could be implemented without the order. The project is the missing piece of the jigsaw between the airport and the investment in high quality jobs at Amids and beyond with the town centre. providing a gateway route for residents, businesses and visitors alike. Without this order being made, this potential would be lost, and the council would, of course, lose the opportunity of investing 38 million of LUF funding investment in the community, benefiting residents and the concentration of local businesses along the route. It is acknowledged that the objectors are impacted by this project and that they will inevitably experience disruption during the construction phase. We have mitigated this by including extensive clauses in our contract for the contractor to minimise disruption and to engage throughout with the objectors and others as regards any work in their vicinity, and by ensuring that the contract contains strict requirements for enabling works for the objectors to ensure security and access are maintained.
Thank you, Ms. Walker. Can I ask you to have in front of you the recognition of Mr. Davison? There are no paragraph numbers, but on the second page of Mr. Davison's recognition, he states that the council effectively withdrew the Excambian option on the 29th of July. Do you see that?
Yes, I can see that.
Yeah. Would you be able to provide us with your understanding of that?
Yeah, I mean, this puzzles me because the option of Harbour Road has always been on the table. I think Mr. Davison confirmed that that it wasn't going to be suitable for Taylor and Fraser. There was some confusion in that Harbour Road is the existing public road, and so I think perhaps you know the council was always talking about Harbour Road being available post construction, and I think Mr. Davison was hoping it would be available during construction. But obviously that the Harbour Road is needed during construction, at least for until the other road is in place. But certainly we haven't withdrawn that. The offer of the Harbour Road is still there post construction or earlier if it's available. And what we said was that because it was rejected by Taylor and Fraser, we didn't proceed with instructing our consultants to undertake detailed accommodation work design, because if it wasn't necessary, but that can be picked up at any time.
I'm right, I understand you're saying that offer remains open from the council's perspective.
It's never been withdrawn, no.
And similarly, in recognition further down the page, Mr. Davison refers to Scottish Government guidance that says that the authority should pay particular attention to business issues, consider the value of consulting suitable, qualified and experienced land agent, and also consider the benefits of assuring officials who speak to landowners and occupiers have an awareness of business issues. Is there anything you would like to say in response to those criticisms?
Well, we've had suitable and qualified staff throughout. Norman Yardley has worked with the council for a number of years and been involved in previous CPOs. He's a chartered civil engineer. He's a member of the Institution of Civil Engineers, and prior to working at the council, he was regional director for Avant Homes. So I think he's extremely qualified. We also had Margaret Law, who was a chartered land surveyor, estate surveyor. We called her. So again, she was fully qualified, and she had worked with us on all the previous CPOs that we had undertaken. Both Margaret and Norman retired, and after Margaret retired, we did use our in-house team for cover the gap. But then we appointed the district valuer within a couple of months in order to assist with this particular objection.
Thank you, Ms. Walker. So I have no further questions on examination in chief.
Thank you.
Good. Mr. Davison, do you have questions in cross-examination?
Yes, if you don't mind. You lead the team, dedicated project manager, Victor Suarez. This is from your full recognition. 2.9, you outline, as you've just said, the circumstances of Norman Yardley retiring and Margaret Lowe retiring. So Mr. Yardley took on well about May 2023 and subsequently retired, so he had no further involvement in the project after that. And from a surveying side and someone with knowledge of compulsory purchase, she was assisted by Margaret Lowe, who retired from the council probably at the end of October 2023. Her out of office reply, she didn't actually tell me she was retiring, of the 11th of November had already confirmed that she had left the council.
Sorry, I'm not sure if there's witness training.
Question.
Yeah.
Mhm.
No,
If you would ask a question, yeah.
Yeah, yes.
Yeah.
Yeah, fine. In terms of my, one of the issues that I have is raised is the general lack of communication from the council. So when Miss Margaret Lowe retired, why were we never informed? Why were we never aware that the council were using in-house surveyors?
So one question at a time, Mr. Davison, please.
Okay. So, okay, why were we never informed that Margaret Lowe was retiring when we found this out by chance?
I don't know that it was necessarily relevant to inform that Margaret was retiring when we had cover. I mean, we have a whole team of in-house estate surveyors, so we had cover, and we just deal with that. So when Margaret retired, any of her emails would have come to me, so then I would have dealt with that. If it had been an issue, then we would have put that up and got a particular name had that been required. If that had been requested or required, I'm just not sure that it's entirely relevant.
I think it's relevant, and I'm trying to demonstrate the generally poor communication within the council to our side throughout the process. So it would have been helpful had we been told Miss Lowe had retired, because after that, as far as we're concerned, our date.
Mr. Davison, it's an opportunity to ask questions. You'll have your opportunity to give evidence.
Okay. What was the relevant CPO experience of the council's in-house staff? Bearing in mind it's quite a niche subject.
The council's done, well, my team have done 3 CPOs, major CPOs for our City Deal projects in the last few years. And obviously, although Margaret Lowe was the lead surveyor on these with us, we have a team of people behind us, just like, for, as you would imagine on any kind of big team. We also, the council, other departments in the council have also done CPOs mainly for housing purposes. So the other surveyors would also, or the estate surveyors would also have an experience of these CPOs. And again, in legal, our legal team, likewise, we have, solicitors who have got experience on these CPOs as well.
Mm-hmm. So what CPO related advice did the council in-house surveyors give you between the time Miss Lowe retired and you instructed the district valuer in March 24?
Any advice we needed at the time, we would have. We always have had a solicitor as well in the team, and they would manage that directly. So if they needed advice from, or if Victor needed advice, we would just go and speak to one of the in-house team. I'm not quite sure.
The point is that I'm trying to make is that our case was that the loss of a yard would always have a detrimental impact on the business. So we needed a relocation solution. That's a valuation issue. So who in the council was tasked with responding to that after Miss Lowe retired?
There wasn't a particular named individual. We just sought advice as and when we need it internally, and then as I say, we then appointed the district valuer because we thought that would be a good way forward.
So Mr. Suarez visited the site with Miss Willam of the council on the 19th of December 23 and accepted the fact that even with the reduced charge, the business was going to be adversely affected and it'd be difficult to operate. So what feedback did they give to you or your in-house surveyors following that meeting?
I'm afraid, Mr. Davison, I'm not entirely. We just always have feedback after each meeting. We would have had feedback and we would have discussed issues if there was issues. Ms. Willen is also a solicitor, and so we would have discussed that, and they would have spoken to the in-house team as required, and would have, as required, and
we have made the point on the 19th September 23 that the yard as it stands after the CPO would not work for the business. I confirmed it by an email on 2 days later. So when between then and now, where we
just a moment, Mr. Davison.
I'm hesitant to interrupt, but I think if Mr. Davis is going to refer to certain meetings or correspondence, it would be helpful for the witness if perhaps if you'd actually point to the particular documents and for yourself.
Right, one second. I'll put my, excuse me. It's actually not one of our documents, but is referred to in our objection letters to submitted to Transport Scotland in January 22.
We've got the objection letter, haven't we? Which is, hold on.
It's number TFB 08 and 09.
So that's the Taylor and Fraser one, yeah.
Yeah, and actually TFB 10 and 11. Bearing in mind that we had flagged up this, it is the most important issue that where the disagreement is at the moment. We've been accepted by Mr. Suarez at the meeting. That would have been escalated obviously up to the in-house council surveyors for their opinion. What actually happened following that?
Again, we need a question, Mr. Davison.
What did the council do when it realised on the 19th September 2023 that it had mistakenly not realised the yard would not work for the business?
Well, first of all, I don't think we've mistakenly thought I understood the yard will not work for the business, because I don't think that has yet been substantiated or established. So when you were talking about Victor and Victoria, sorry, Mr. Suarez and Ms. Willen met, and you know, when they've come back, they've discussed the fact that that the yard, that there were concerns and everything else. So we continue to look at these. I'm not quite sure. So yeah, we speak to in-house surveyors, we speak to solicitors, we do all that just as a matter of, business as usual.
So,
But I don't think there was any kind of moment there when we thought that, I don't think anything had been evidenced in that meeting that the yard might not work. So I think at that point they continued to speak with Mr. Taylor, and continued to, and also brought in, Mr. Bathgate. And so they continued to look at and ask for information on the yard and how the operations work.
Mr. Bathgate, in recognition, confirms that his last, bar the meeting with the reporter on the 15th of August, his involvement with Taylor and Fraser ended in May 2023. So he wasn't involved, as far as we're aware, after December. Is that not correct?
Don't think so, but I think we'll need to speak like.
I cover it in Mr. Bathgate's recognition, so we can move on from that. Why did it take so long? If the district valuer was contacted instructed to act with the council in March, why did it take him effectively till July to engage?
I don't think it took him till July to engage. We were doing, as I say, we were doing a lot of work in the background, and he needs time to kind of form a view. I'm just trying to see where the documents of the engagement are marked. Do you know where our schedule of?
Just while you're looking, Ms. Walker, Ms. Davison, I'm not quite sure where we are in time. Could we perhaps refer to the timeline in the agreed statement of facts, and just let me know where we are in time, so I can fully understand it.
Where do you find the time?
Ms. Walker should be in tab or of the same folder of recognitions.
Statement of agreed matters, number 4. Okay, sorry.
So, just looking at the timeline in the statement of agreed matters, what time are we talking about, Mr. Davison?
The council, 1 second. The 23rd of March 24, Renfrewshire Council engaged the district valuer.
Right. Okay. I'm with you now.
So whilst the district valuer went to the site in just trying to help with the question in June, we didn't actually engage with Graham and Sybil, myself, until July. Seems a long time, so I'm just wondering why it took so long.
He was engaging with us, and we were providing the background information, and we were asking him to look at a number of things, including obviously this objection. He needed time to obviously prepare valuation for us. We had various meetings with him in that period.
Okay, so but he didn't engage with me until July.
I'm just.
You say that the district valuer.
Just one at a time. Were you completing that answer, Ms. Walker? Yeah.
Yeah.
Could you just complete it?
Because I can see in the timeline here that the district valuer contacted Mr. Davison on the 10th of May to confirm that he was advising the council.
My point is he didn't actually
Well-
meaningfully engage with me until July, and I'm just asking why it took so long, but I think we've exhausted that.
Right, well, I was still answering because I can see from the record here, which is why I was a bit surprised when you said July. He contacted you the 10th of May. You provided the council with indicative costs on the 23rd of May, which were also passed to the district valuer. And so there was work, there was various, things ongoing. So it depends, you obviously are talking about engagement as, something very specific rather than interaction.
He picked up the phone and spoke to me on the 10th of May, but said nothing material. My point is, I don't think the delay. But fine, we'll move on to the next question.
These matters for your evidence, Mr. Davison. You can say that then, yeah.
Yeah. You say the district value refreshed the council's valuation, which was 157,000 an acre to 250,000 an acre. Do you think an increase of 60% is quite a lot?
Yep. Yes, I do.
Would that suggest to you that any in-house advice you were getting on compulsory purchase wasn't perhaps reliable?
No, I don't think so. I think we looked I think there was more information available. I think that Taylor and Fraser, I think, it was just the way things were. Our in-house valuations are generally very accurate.
Well, what additional information was available? They were losing just under an acre. It didn't change.
I'm not a valuer, Mr. Davidson. But we take advice from registered valuers. So I don't think you can imply that the council's in-house registered valuer is, not accurate. They would have provided a valuation on what they had available at the time.
A 60% differential would suggest to me it's not accurate.
I think, Mr. Davison, the council internal valuation only looked at one aspect of your potential claim. I think, I think there are differences, but as I say, I'm not a valuer, so I don't. That's why we have registered valuers.
Is that sorry? Just a moment. Is that a matter for Mr. Suarez's evidence? Is that, or is that?
No, Mr. The problem is that none of the witnesses and none of the people I've been engaged with are notionally the district valuer are able to comment on valuation matters.
But I mean, valuation ultimately is not. It's not. Well, I'm not. I understand your point about about engagement, or your point. Your case is in this respect is about engagement. I mean, ultimately, valuation is not a matter for this inquiry. It's about the CPO. That's right, isn't it, Mr. Davison?
It's also making sure that people have are getting the proper advice, bearing in mind how important it is, and be out by 60% on the district valuer's assessment, and it'll probably be 70% if there's a agreement. I just suggesting that implies that it certainly demonstrates a lack of knowledge.
I also don't recognise your initial figure, Mr. Davison. I'm afraid I don't know where that figure has come from. Can't see it in this. If you can point me to where the figure was it 157? You said.
Yes, that came from Mr. Beveridge. I think it might actually be on the statement of agreed facts as well.
I think then, Mr. Davison, if you don't mind, when something's being negotiated, it doesn't necessarily accurately reflect the valuation. When you're negotiating, you don't go in with your top offer. So I think that's maybe what you're referring to was a kind of range. So
no,
I have the figures in front of me because I don't think it's in this evidence here, but I think our in-house valuer would give us a range, which is always perfectly normal, as does the district valuer. And so I think what you're doing is kind of almost misconstruing this 60-70%, I don't think is actually accurate. I can't see the evidence where it comes from, so it's very difficult for me to answer.
1 second.
When the district valuer first spoke to you,
Okay.
Mr. Davidson, he was trying to sound out what sort of figure were you looking for, and I think that's the figure you're quoting here, which is not necessarily a valuation figure.
No,
So I think
it's not actually. That's not the figure I was asking for. That's his figure. Yeah, the agreed statement of facts, 24th of July 24.
July, right. Just a moment. Right. Okay, I've got 24th. Yeah.
So that says the DV 250,000 an acre, Bremen Civil 300,000 an acre, and the council's about 150,000 an acre. So that's.
I think you're misconstruing that as an internal valuation figure rather than a kind of opening negotiation figure.
Mrs. Walker, it is the agreed statement of facts, and it does say the council's own in-house valuation.
Yeah, I'm just trying to explain but yes, that's what it says in the agreed statement of facts.
The point I'm making is you have to be fair and reasonable throughout. So going in,
Would it be a question rather than a point?
Yes. So do you agree that going in with such a low offer as that would have been unreasonable?
No, I don't think so. I think it was just to go in with to try and open up the conversation and see what we were looking at.
Well, I think to engage reasonably, you have to. My view is you have to make a reasonable offer, but we obviously have to agree to disagree.
It needs a question, Mr. Davison. Yeah.
Thank you. So if I can refer you to TBF 25, the article in Property Week, which highlighted the two significant compulsory purchase orders that had been refused by the inspector. What did the council do once it found out about these to manage risks for the project?
I'm sorry, where am I looking?
TBF 25.
This one.
Well, recent high-profile snubs cast out in future of CPOs.
Yeah, no, we did look at them, and as I say, we've had advice from our legal advisors, and we've had advice from the district valuer, and we don't feel that these cases are necessarily appropriate here or similar here. We feel we have engaged. We've had difficulty getting information to move things on from Taylor and Fraser.
Okay. I'll park that question because it's about meaningful engagement, and I'll cover that again. You said the district valuer was to respond efficiently and negotiate with the objectors, considering all options. What do you think responding efficiently and negotiating an objector should look like?
Well, I think the district valuer is very experienced in dealing with these things. I think the district valuer has given us advice, and we've discussed at each stage what his advice is. He's also tried to get information on all the heads of claim. Originally we were hoping, as you know, that we could come to some sort of agreement and remove the objections. That's not been possible because there's not been sufficient information for the district valuer to make a clear or any recommendation to the council.
Do you think it's reasonable that the district valuer came to his opinion without speaking to me, without speaking to Mr. Taylor, or without actually walking around the whole site?
Hold on, but which opinion are we talking about?
He's actually saying that there's no relocation yard needed because of business.
Where is that, Mr. Davison? What document are we referring to?
That's in the It's a statement of reasons again. And I think it's 30th of July.
Is it the statement of agreed matters?
Yes,
Mr.
sorry,
Dixon?
statement of agreed matters. Yes, so that's 1 second. The district value's opinion that neither the Harbour Road alternative off-yard site on Abercorn Street are necessary to enable Taylor and Fraser to continue to operate on or after the work. So if Mr. Beveridge or the district valuers didn't actually speak with me, didn't speak with Mr. Taylor, didn't actually walk around the premises, do you think it's reasonable that he made this judgment without speaking to anyone?
I think he visited the premises on a few occasions, and you know, the district valuer's the expert in this regard, not me. And he's given us advice. He's also looked at historical information, as far as I'm aware, and he's come to that opinion. He then, you know, in the update, he did speak in great detail on the 15th of August, and you know, his position hasn't substantially changed. So I think it has been reasonable, yes.
But he didn't.
He's a, you know, the district valuer is appointed, you know, as an expert for the council. You know, it's for him to know what he needs to, you know, information he needs in order to make his assessment, and that's what he's done.
I
don't think
worked for the district valuer's office
Right.
for 35 years.
Well, just a moment, Ms. Davison, yeah. Okay, let Mr. Walker finish her answer.
I don't think it's for me to, you know, question how the district valuer does his job. That's what he's employed for. We employ him for his advice and his expertise. I don't think I'm in a position to say whether I think he's done it, you know, but whether he does it properly or not. Because of course, if he's the registered valuer. He knows what he needs to find.
Would the man on the Clapham omnibus say that it was reasonable for someone to make a decision so important that the business doesn't need a yard without walking around the whole business, speaking with Mr. Taylor or myself?
As I say, I don't think it's for the man in the Clapham omnibus to make that assessment. I think that's for somebody with experience to make that assessment. And I would think the district valuer has had sufficient information in order to make that assessment.
Mm-hmm. It's referred to in the council's statement of reasons. Excuse me, the principle of a relocation site is, sorry, an Excambian site is stated in the council statement of reasons and had been accepted by Norman Yardley in 2022. And Mr. Yardley was also going to consider other sites. So how has it transpired? We're now in a situation where the principle of a relocation yard was accepted in 2022, and we find out 2.5 years later that the council has changed its mind.
I don't think ever. I mean, Norman didn't ever agree in principle to a relocation yard. I mean, it's all part of the, you know, discussions and that were ongoing. You know, Norman certainly never agreed to the principle of a relocation yard. He wouldn't have done that. But he's obviously said that they'll, you know, in the grand scheme of things, everybody was looking at options to see what could be considered.
So do you not think that
I think whilst he might have been, you know, assisting and looking to see what was available and see if there was any easy options in order to get the, you know, to get the objection off the table or whatever. I don't think anybody ever agreed to the principle of a relocation yard, Mr. Davison.
But why were we discussing an Excambian if it's not a relocation option?
Well, that was land that Mr. Taylor had referred to, that we'd gone back and looked at and said, yeah, absolutely, that's land that will be redundant after the construction contract's completed, and therefore we had no objection. I mean, but it wasn't done on the you know, it wasn't done on that principle. It was just like, yes, absolutely, if that helps, that would work. That was all that was. It was just to try and be helpful. The land, that Mr. Taylor had asked us to look at.
If you look at the statement of agreed facts, Mr. Taylor says throughout the meetings that he needs other land.
Yep.
So the Scambian land was to replace what he was losing. So on what basis, I repeat, do you think that Mr. Taylor was not led to believe the council had accepted that he needed a relocation yard in 2002?
In 2002. I'm confused, Mr. Davison.
Well, we're referring to the statement of reasons then. I'm sure I agreed facts.
I wonder if it's just, did Mr. Davison mean 2022 rather than 2000?
Oh, sorry, that's 2022. Sorry. If we go to 2022, right?
Right. I think as I say, I don't think there was ever any agreement in principle to agree any heads of claim in principle. I think this was all just part of normal discussions and seeing what we could do. And we would always, if there was an easy option like the Harbour Road land, if that had been sufficient, that would have been a fairly easy thing to do and if it had worked for Mr. Taylor, then the council would have that would have been fine. But I don't think it was never linked to an acceptance of, because I don't think even to date that Taylor and Fraser have demonstrated the need for another yard. The council wouldn't be able to agree in principle until we had sufficient evidence. That doesn't mean that we couldn't agree if there was Harbour Road land available. We could make a case for saying, that's a sensible way to proceed. But that's not the same as having approval to say that a certain head of claim had been accepted at that stage. And my screen has changed and I can only see Mr. Davison now. I'm not quite sure why.
Sorry about that.
We're still here. I'm not sure.
I'll wait and see if something
we'll
maybe.
We'll need to take a break shortly, and so that I'm sure that can be adjusted.
I've got everyone back now. Yep. I think something was bumped.
Right. If I can go to the statement of agreed facts, 12th of January 22. Mr. Taylor confirmed Taylor and Fraser are willing to open discussions on options. His preference is to gain land at Harbour Road, e.g. in Excambian, so his overall land holding remains the same. Not pretty clear that he needed extra land if he was to lose plot 37.
I think it's clear that he's asked for extra land. That doesn't, and I think there's a big difference, Mr. Davison, between us confirming that a head of claim has been substantiated and be willing to try and resolve something or mitigate that. I think that's different. So Norman would have discussed Harbour Road and said if that was available, yes, that's an option, but that's not the same as confirming that he's got approval that we agree that a certain head of claim has been substantiated.
We move it on to the 23rd of February 22, again from the agreed statement of facts. Mr. Yardley is actually looking for other areas owned by the council that he could possibly give to Mr. Taylor.
Yep, and this is perfectly normal. This is perfectly normal that we would, as part of our consultation and assistance, if there was suitable land that the council own, to avoid objections and to avoid public local inquiries and everything else, that's absolutely something we would always look at. We will always try and assist, but that's not the same. What I'm saying is that's not the same as having approval that a certain that the need for an additional yard has been evidenced. That's two different things. So the fact that we're willing to look at, cooperate, or try and help and try and, that's not the same as saying that Taylor and Fraser had evidence that another yard was required, if I'm making sense. it's two different things we're talking about here. We're talking about the fact that we have communicated, we've had meetings, we've tried to discuss what would make it easier. But that doesn't mean there was an acceptance that alternative land was required that have been evident.
But if one party says that's what they need, and the other party for 2.5 years doesn't correct them on that, do you think that is reasonable?
Well, I think you're kind of trying to put words in my mouth here. This is all part of the normal process. We talk to all the affected parties. If there's an easy win, like the land at Harbour Road, that's something we would accommodate. I don't think we ever had any discussions with Taylor and Fraser, to my knowledge, that we accepted or that they had evidence, because in order for us to get approval for a certain head of claim, we would have to, if it was a specific, we need another yard or whatever, we would need Taylor and Fraser to have substantiated that. We couldn't do that on a meeting notes, but as Norman was trying really hard to make sure that that the impacts were alleviated, I'm not putting this very well, but that's actually all just part of the consultation and the discussions that we'd had on an ongoing basis.
Mm.
If there was land adjacent to the site that the council owned, that's something we could look at. Absolutely. But it doesn't mean that there's necessarily an acceptance. It's all just part of the process. It's part of the CPO process.
Can you understand if Mr. Taylor, who was unrepresented at this time, had meetings with the council, why it was his understanding, because no one had said to the contrary, that he didn't need any extra land, bearing in mind there have been discussions about the Escambian and potentially other sites?
Yeah, well, as I say, Mr. Davison, this is the first that this has been put to me. I've never heard Mr. Taylor or anyone else suggest that this has been a misconception since 2022 until just now when you've raised it. I don't think there was ever any discussions that there was an acceptance of that. I think this was all just part of the negotiation, part of the interaction between the objectors or prior to the CPO and everything. It was just all part of the process, the consultation and the interaction that we had. And we were trying, I think it evidences, in fact, that we have tried all along to assist.
Well, the option for the Escambian land, we were told, effectively was withdrawn on the 29th of July this year, obviously 2.5 years after it was first discussed. So when did you first become aware that this land was required for the contract and couldn't actually be handed over immediately?
Well, as I say, I think we discussed that earlier. I think I covered that earlier. The land isn't withdrawn; it's still there. Who
knows why it wasn't available immediately?
I think possibly Mr. Davison. It had been a misunderstanding on your part, because I think before that the land's a public road, so it's got to be, we can't shut that till we have the other road constructed. So I think on the face of it, it's probably fairly obvious, which is why we were maybe talking to cross purposes, because we thought it was fairly obvious that it wouldn't be available until the new road was constructed, because obviously businesses, including Taylor and Fraser, need that road to access their businesses. So we can't close that until the new road is constructed. So I think that's just been unfortunate. But yeah, the Harbour Road is still available after construction, or possibly before the end of construction. It's still on the table. It has not been withdrawn.
But back to my question. So you're agreeing it took 2.5 years for the council to advise for the first time that the land was not immediately available?
Well, I don't think we were ever asked that. I think we just always had assumed, as I say, that I think we'd always, it was always quite clear that the land's a public road, and so it wouldn't have been available until another public road was constructed. So I think it's just been a misunderstanding.
Yeah. I think you're answering the question. I'm asking, where was anyone ever told between January 22, when effectively discussions began, and July 24, when we were told that it wasn't going to be immediately available? Did anyone from the council tell Mr. Taylor that?
I think we only ever discussed with Mr. Taylor that the land would be available after the contract, and there's been a misunderstanding, as I said. So the first time, the first time we were asked, the first time we were asked,
No,
if
no, Mr. Taylor, wait for the end of Mr. Davison, wait for the end of the answer.
if the first time we were asked if it was available during the construction period was in July, and we confirmed it wasn't. We were never asked that before.
You were asked for an Escambian site, so Mr. Taylor could continue to operate immediately upon vesting. And it took 2.5 years for the council to tell him that is not possible. Is that not correct?
So again, just again, if Mr. Davidson is going to say that was put to the council and 2.5 years ago, is there again a document reference or something that he's referring to for that?
Yeah, the discussions about Escambian land are documented in the statement of facts. There's several references to Escambian lands and other pieces of land, all within the statement of facts. Obviously the meeting of January 12th of January 22.
Does that read that?
The 30th of November 22. And the 24th of May 23. Just being 3 examples. I think there's more. So again, in terms of reasonable engagement, I ask the question again. Was it reasonable to wait 2.5 years to tell Mr. Taylor that it wasn't a realistic option?
As I say, Mr. Davison, we had always said Harbour Road was available and it's still available, but we were never asked if it was available during the construction period until July, because obviously it's a public road, so I think we would have thought it was fairly obvious it wasn't available. And when you specifically asked in July, we confirmed that no, it wasn't going to be available until it was able to be stocked up, which would be so.
Was it not you that told?
I don't think it's an evidence of the accounts being unreasonable. I think it was just, we thought it was quite obvious. It's a public road, so we were just assuming, we were discussing that it was available post-construction when the road could be stocked up. And you're now telling us, or you told us in July, you were assuming it was available from the start of the contract. That was just never the case. So I don't think you can possibly say that that's evidence of us waiting 2.5 years to confirm something.
Was it
That's
not?
just twisting what's happened.
Was it not yourself that told me on the 29th of July for the first time that it would not be immediately available?
When you asked, yes,
I didn't ask. When did I ask?
Somebody asked, because somebody asked. I think you must have asked on a phone call or something. Somebody asked, and we went check at what point it might be available, which I think Ms. Willen perhaps responded to and said 20 months or something after construction was our best guess.
The blue, I was told on the 29th of July that it wasn't to be immediately available. I did not ask.
Well, somebody asked us, because that's, that's when we...
It must have been an internal someone, but it wasn't from our side.
I think we're speaking into evidence again.
Yes, I think so, yeah. No, no. Have you got any more questions on the subject? And I think we've
No,
covered
I'm going to move on from that one. I think we've exhausted that one, but
it. Well, but before we do, it's 11:15 now. Should we take a break now, and then we can resume at 11:30? Is that
sure.
suitable for everyone?
Yes.
Yep. Okay. Right.
Thank you.
So back at 11:30, everyone.
Thank you.
No, I catch a can, but.
You know where I'm going
Where are you going?
on Friday the 6th of September. I'm going to see Sandra and Paisley.
Good for you.
Did you know?
No.
There you go.
Oh,
She's back in Paisley.
We're just waiting for Mr. Davis and Mr. Taylor to return.
I think Mr. Taylor may join us later, so I think we can look on.
Proceed.
It's okay with you?
Absolutely. We'll need Mrs. Walker too, obviously.
Sure.
Sorry, I'm here. I had forgotten to switch the camera back on.
Go ahead, Mr. Davis.
So in terms of reasonable engagement, as of today, the district valuer has not even begun discussions with Graham Sybil to explain how he reached his conclusion that the business did not need a large yard. Do you think that's reasonable?
I think that's misleading, Mr. Davison. The district valuer has confirmed to me that he has asked for information that, and he said no detailed explanation has been provided as to date. And he's asked for information on records on the yards to show how busy they are. And he's been advised that there aren't records available that he can see. There's no written records. And so I think it's quite misleading to say that it's not reasonable, because I think he's trying to get information that if in order to change his view, you need to provide information, and I don't think he's had the information provided that would enable him to change a view. So he's made his view on the information he has available to him.
He made his view on that in July, and subsequently had evidence produced in early August and on the 15th of August to further support the view the yard is crucial.
So
why hasn't he?
But first, this is a question. Second, what are we looking at in terms of the evidence? What questions are we looking at here?
Well, Ms. Walker referred to the point that we had passed on information to the district valuer on the 15th of August, and she thought that was incomplete. I'm just saying it was passed on before then, and we await a response.
Right.
But the difficulty that I'm finding is that no one explains their decisions to us, so we can't understand how these decisions are being made, and we're building up a case that is unreasonable engagement. Okay, I'll move on. See, at 2.7 of your recognition, the project significantly improves connectivity in the area and will have a consequent increase in value of land and business. Would you say that this applies to the Barney Group and to Taylor and Fraser?
I think the residual value of land, again, I'm not a valuer, but that's the information that that the business case has demonstrated, that the whole area will have a general increase in land value. And if you're asking me with the with the CPO and the changes in land value, but the actual base land value rate, I believe, will increase in the area. Yes.
Where's that evidenced?
In the business case. Now, if you're wanting me to dig out the business case and find evidence, then
I don't
do that right now. But yeah, the business case was all about the benefits. The business case demonstrated the benefits to the whole area of this scheme proceeding, which is why we got the levelling up funding and such a high award for it, because we demonstrated quite clearly the huge benefits to the whole area. The local business.
Mr. Your answer,
There was
Walker.
nothing specific to the objectors in that. So we have no reason to believe either way whether their value of their land would go up or down.
No, we didn't look at individual premises. No, it was
No,
a whole,
that's fine.
all
Thank you.
businesses.
Thank you.
Businesses
But-
area.
Ms. Davison, you asked a question. Can you let Mrs. Walker finish it? So could you
Sorry,
just
of course.
repeat your answer, Mrs. Walker?
So the business case didn't look at individual businesses. No, it would have looked at the general benefits to all the businesses in the area. So there was a general increase in land value. That was part of the benefits in the business case. But no, we didn't look at the objector's land in particular.
Okay. At 212, you say the strategy to date has been to contact and engage with all owners, which has happened, and to agree land compensation specifically as part of the vesting arrangements. So on that basis, would you agree that engagement is a fundamental tenet of the CPO process, and a failure to engage constructively can lead to a heightened level of risk at today's inquiry?
I'm not quite sure. I think I'm not quite sure what you're asking me, but we've engaged with all owners and we've given all owners the information, and we're all interested. It's not all owners. There's obviously other interests other than just owners, and some have contacted us and confirmed they're happy to wait, and some haven't contacted us at all, but they've all got the information and are able to contact us, and we would deal with any contact on as required on the basis that, of their requirements.
My question was just a more generic one. Would you agree that engagement is a fundamental tenet of the CPO process?
Yes, absolutely.
So, thank you. You say that all required accommodation works affecting individual premises and owners have been discussed and agreed as part of the engagement process. A couple of queries. Accommodation works are part of the compensation. So when you were discussing compensation issues, such as accommodation works, had you followed Scottish Government guidance, TB3 and TB4 from memory, to tell people to get professional advice?
We send everybody, when we did our land referencing and when we did our notification of the CPO, we send the links to all the guidance for all interested parties, so that they're aware that they're entitled to representation. And I'm not quite following the question, Mr. Davison.
So when did you send the links and people of advising them to get professional advice and giving them the links to the Scottish Government information?
I think that's in the agreed timeline. I think it was in September 23, perhaps. But we'd spoken to everyone before then. This was just, and we would always say, when we spoke to them before then, and when I say we, it wasn't me personally, but Margaret and Norman generally, they always will say to them as well that you're entitled to representation, and then we would have formalised it when we sent the land referencing letters, which was the 21st of September, 2023. And at that stage, it would have been in writing, and we sent them the links to the guidance, and we also gave a contact for them if anyone that wants to contact the council.
So that the information was sent on the 21st of September 23, is that right?
Yes, but that wasn't our first engagement with every party, but yes.
The accommodation works discussions referred to in the statement of reasons of 14th of September referred to them being well underway. So how did you tell people of their rights, and how can you demonstrate that happened?
So just take back to the 14th of September. We're referring to the timeline, are we here?
No, it's not the timeline. It's about reasonable engagement and acting fairly. So my concern here is that people were unrepresented and had not been advised to take advice when the council were engaging with them.
I know, but I just wonder what the relevance. Where did the 14th of September date come from?
But the 14th
they made the order, right?
The 14th of September is when the
2023
statement
we're
of
talking
reasons was written.
Right, good.
So in the statement of reasons, it says that those letters have already been sent, but it seems they were sent a week later. So I'm just trying to get to the bottom of any earlier information that was given to those affected who were already engaging with you about accommodation works, which are part of the valuation, where they unrepresented and where they given proper advice.
Sorry, Ms. Walker, please. And so I'm struggling to follow here. Just Mr. Davison's referring to, and was referred to guidance, and making some suggestions that the council's not following guidance. And Mr. Davison is going to do that. I think it would be only fair to the witness that guidance is actually put to them and the correct reference. And also, I'm struggling to follow exactly what the point is without that as well.
Are you going to do that, Mr. Davison? Are you going to?
Sorry, I thought I referred to TBO3 and TBO4.
Well, can we have a look at those documents and the relevant parts of them? Can you speak us to the relevant parts of them?
Yep, in a second. Yeah, I can go to TBF04. Any of paragraphs 4.1, 5.2, or 5.8.
Can we have a specific paragraph?
4.1.
Right. So TB, which one is it?
TFB04.
04.
Paragraph 2.1, 4.1. I'll jump here and read it.
The point is you're strongly advised to employ a suitably qualified and experienced professional property valuer to advise you the reasonable costs of which can be reclaimed. This section provides a brief introduction to the types of compensation may be entitled to. Right. Yeah.
So, what I'm suggesting is that if people were not informed of these rights, then it was unreasonable of the council to enter into negotiations about accommodation work.
Are you going to put a question to them on that point?
Was it reasonable for the council to enter into dialogue about accommodation works presumably prior to the statement of reasons was written without complying with Scottish Government guidance, compulsory purchase in Scotland guide for property owners and occupiers?
As I say, I think Mr. Davison, this is all part of the process, and so there was no final accommodation works or anything else agreed with any business owner in advance of this date. That's an ongoing process. We keep discussing all the way through the whole process until such times as and I think you'd probably be better speaking to Mr. Suarez and Mr. Bathgate on actually that process, because they're much more involved in the detail. But we even amend accommodation works at times after our contract's let to make sure that that everything and other owners are impacted interests are accommodated during the works. So I'm just not quite understanding what, I think what we've done has been reasonable. Yes, we've been in discussions with other parties all the way through, but we haven't entered into any legal agreements without anyone having legal advice or valuation advice. If that's what you're asking me, we would never enter a legal agreement or a valuation without ensuring the other party knows that they're entitled to advice and that we would be paying reasonable costs.
Well,
So I don't think anything has ever gone that far, is
Well,
my answer to your question.
your statement of reason does suggest that accommodation works discussions were well advanced, including with Taylor and Fraser. So that's the point I'm getting at. But okay.
Do you want to put that as a question?
Well, I
should
think
they have been advanced?
I think
advanced?
I think I have put it, but it's not being answered. So,
Well, I don't think it hasn't been answered, Mr. Davison. I think the conversations were when we say they're advanced, and again, I think you'll need to ask Mr. Suarez and Mr. Bathgate exactly what stage they were at certain times. I think we were talking about, don't worry, your site will be secure. Don't worry, you'll have permanent 24/7 access, and that kind of advanced, rather than this is a legal agreement showing what you're going to get. Please sign here. I think there's a big difference in kind of just the process and trying to understand what the implications might be. And, we would never enter into a legal agreement with a third party without advising them that they should seek their own legal advice or valuation advice or anything else. So we'd sort of, so that sort of thing been advanced, that we would be, making sure the site was secure, that we'd be pleading for certain provisions in our contract on access, and that kind of advanced. But as I say, I think we'd be better placed asking the technical team on that.
Okay, I will ask them. Thank you. I'm going to refer you to Scottish Government Guide for Property Owners and Occupiers, which is
That's the one we're on, isn't it?
is it right? Paragraph 2.4. And just open that.
The acquiring authority is expected to take adequate steps to identify all those with an interest in property they are seeking to purchase, communicate with all owners and tenants in a clear and accessible way, and provide information on what owners and tenants can do to represent their interests and what compensation they might be entitled to explain why they are seeking to purchase the land, what other options have been considered, and when and how they intend to deliver the project, minimise the impact of the quality purchase project on affected properties, and to help affected homeowners and businesses relocate whenever possible.
This brings us back to the district valuer. So we've had discussions about land value, but the district valuer has declined so far to give any evidence to support his valuation of 250,000 an acre. Do you think that's reasonable? And complies with that paragraph? If you're,
I'm not well.
So if you're supposed to communicate in a clear and accessible way to provide information, then surely we have the right to know on what basis the council's advisor is reaching his decisions.
I think on the valuation of the plot 37, you have had discussions with the district valuer, and my feedback from these conversations were that, that you were actually pretty close in your valuations, and that the only difference was how you value the ramp, perhaps.
No,
I think you have had discussions on that, and I
You
know
don't-
the same basis as you've kind of done your valuation, more or less.
my point was, is it reasonable for the district valuer to suggest a figure but without giving any evidence?
Sorry.
Just going back to your question, Mr. Davison. I mean, the council's the statement of agreed matters says in respect of 30th of July 2024, the council's valuation was around 150,000. VNS claim is 286,000. But the BV. I mean, what are we saying? Is the council's valuation currently 150,000? I'm not sure if that's the evidence, is it?
The council's currently valuation in terms of per acre is 250,000. But what I'm saying is, whereas we've evidenced our claim of 300, we still await any evidence from the district valuer for his assessment. So,
or of 250,000.
Yes.
Right. Okay.
Right, I don't think that's the case. But again, I couldn't answer that right now because obviously the district valuer and yourself are having valuation discussions. My understanding is that you were using very comparable evidence, you and the district valuer, and so I think that has been explained to you. But
the district valuer hasn't. Sorry.
It's difficult for me to say because I wasn't actually there. But my feedback is that your actual valuations and therefore the evidence base for your valuation and the district valuer's valuation are very similar. That was my feedback, and so I'm not quite understanding why you think, what it.
They're 50,000 an acre apart, and the district valuer still hasn't provided any evidence in support of this figure, not one comparison. So I'm just asking, is that reasonable?
I can't answer that, Mr. Davison. I don't think that's the case. But I can't answer that because I would need to check with the district valuer. But that's not my understanding. No, my understanding is that has been discussed with yourself.
Yeah. No comparisons.
My understanding is that you did discuss comparisons, but as I say, I can't confirm that without confirming with the district valuer. My understanding is that you were very close in your comparisons and you were using similar comparisons, and so that's my understanding.
Unfortunately, I disagree. But the other issue is the district valuer has declined to give any comparisons for any impact on the value of the retained buildings, citing it can't give any evidence for GDPR data security reasons.
Sorry, I am a little concerned that we are straying into valuation matters, well, not strictly matters for the inquiry. Now, I understand Mr. Davison may want to ask questions around engagement, but it does seem like we are straying into the areas that may be in dispute between them as the compensation and valuation, which we're not really here to deal with today.
Well, Mr. Davison.
Well, I think the difficulty I have is that part of my point here is engagement about valuation issues and the attitude of the district valuer not to give comparisons, to cite GDPR reasons is he can't give evidence, just builds up to me the share of not acting in a reasonable and transparent way. It's difficult to negotiate with someone like that, and I'm just saying, is it reasonable that I'm expected to negotiate with someone who thus far plans to give any evidence and cites GDPR reasons as another reason why he can't tell me anything?
Yeah, I think on that basis, I think it's a relevant point, Mr. McMurray. So I'm going to allow questioning on that basis. I would appreciate though if you're referring to Mr. Davison, if you're referring to district valuer alleging something, if you could point me to a document in which the matter that the district valuer's position is demonstrated either in the statement of agreed matters or in the other documents that are being submitted.
Yeah, I'm not 100% sure I have that. I'll just check. No, it's not one of our core documents.
You would recall a claim of it somewhere. Perhaps it was in your statement of case, but that obviously isn't evidence.
No, I think that information was given to me after the statement of case was written. Well, I said I haven't produced it as a core document. Okay.
Is it in your own recognition, Mr. Davison?
No, it's not. I'm going to say that I cannot prove that to you today by referring you to the paper. The core documents had to be in by the 30th of July, and I'm pretty sure that information from the district valuer about GDPR came after that. I'll have to provide a copy of it later if I'm allowed to, but
well, I wouldn't want it later. If you wanted to submit it, I would want the witness to see it now. So if you want to submit it now, so you can put it to the witness, then we can see what Mr. McMurray has to say about that.
If I can find it.
I'd say I'm not sure. Well, I think it's relevant. I've said it. I think the point is relevant. I'm not sure how far it gets you, Mr. Davison.
No, my point is it's I think it's unreasonable to negotiate with someone who doesn't even give you evidence. And if the Scottish Government's vision is for compensation to be clear and transparent, and nothing is clear and transparent if the agent for the council declines to give any evidence. That's my point. All right, everyone, I'll be with you in a second.
Am I allowed to come in? Because I say
feel free.
I know the point you're making, Mr. Davison, and I think the district valuer has confirmed to you that your evidence and his evidence are very similar, and therefore he hasn't, so there's been no need, rather than it's been no communication. I think he's communicated to you that the evidence is very similar, and that the main difference between the full amounts are the treatment of the ramp rather than the evidence. So I think it's probably, in my view, a bit of a non-point, because I think that has been communicated to you, that there's been no need for him to go and submit other evidence because it's so similar to the evidence you already submitted. There's no big disagreement there, but the disagreement between you on the valuation of the plot is the treatment of the ramp, which isn't an evidence. That's a different conversation, I suppose. And so therefore, that's my understanding as to what the position is. That
I wish it was that simple. But
Perhaps we deal with it, Mr. Davison, is if you want to look for the document over lunchtime,
yeah, I will do.
and forward it to parties at that
Well,
point, and then we could return to this point if
Thank
Mrs.
you.
Walker has finished her evidence, then we can maybe bring her back if that's convenient, and we can address it at that point, and perhaps we can move on to another point.
Yep, sure. Can you tell me why the council quite willfully continue to describe the land as being unused in its internal meeting notes of 30th of November 22 and 24th of May 23, as per the agreed statement of facts, whenever the business had told them it was used?
I think I would need to look up the particular document you're referring to, but I don't think we've ever suggested the yard was completely unused. I think
should we go to the statement of facts? So I think that
Yeah.
is referred to in the statement of facts.
So the first one was 30th of November 22. So the council actually put in the land was unused, and I put in a comment not agreed. It was accepted that the land was ever unused. So the council in their internal notes, which were not shared with the objectors, are describing the land as unused land. On the 24th of May, 23. It's the 12th of January 22, or is that the one I just said?
Certainly 12th of January 2022 and 30th of November 2022.
Sorry, 12. So those two meetings, it said it was unused land, and I'm just trying to. Mr. Taylor had been explaining how the land was used. So how did council come away with those from those meetings, thinking it was unused?
I think it's probably a bit of semantics, and if it was internal notes, I think, again, Mr. Bathgate was at the meetings that you're discussing, and I think you'd be better speaking to him. But I think the references to the ramp, meaning it was underutilized rather than, unused. But again, I would imagine that you're better clarifying that with Mr. Bathgate and Mr. Suarez. I think it's probably semantics. I don't think anybody ever thought the yard was unused as a whole. It was just certain areas that were underutilized. It's perhaps a better way of describing it.
Well, it is described as unused in those internal notes, though.
Yep.
Thank you.
Thank you. I think several people reading these notes would have understood what was intended by that wording, but it's probably clumsy wording.
In 3.5 of your recognition, again, you talk about the approach to engagement, and you say a log of contacts with every claimant. If you did keep a log of contact, why is it not one of the core documents? Bearing in mind, our case is a large part of it is on the poor communication.
I think we've just provided the log of contact with the objector.
If discussions about accommodation work started But we didn't know who was going to object to the proposal. So there should be a log of the council's contact with all parties.
Mr. Davison, that there's an agreed statement. Are there particular matters? I mean, there's obviously points that are not agreed in the agreed statement. But generally speaking, does that not cover the council's contact with the objectors, or have I misunderstood?
Well, building up a picture that looks like contact with objectors, but and the reality is that it's not. The number of their entries relate to meetings. They don't tell you what they're about. And one of them I found out it was actually about borrowing a forklift.
Well, why don't you focus in on those points? Or, I suppose it's I have to ask about the log of contact. Okay, go ahead.
So I was the meeting of 14th of June 21, where no meeting notes available. I mean, that seems to be from subsequent information given to me by Mr. McGill, mechanical director for Taylor and Fraser. In fact, it might have just been about applicants for non-intrusive surveys, so it's not really engaging about the compensation.
Well, is that in your recognition, Mr. Davison?
No,
is that Mr. Taylor's recognition?
No, because of the council referred to documents that have been provided by Mr. McGill on I think the 30th of July, which I knew nothing about. It's taken me time to find out what those documents actually were. So it wasn't in my recognition because of the fact that this was.
Okay. So you'll address that in your evidence.
Yeah. Okay. The other evidence in terms of whether there is a completed log of lists is that whenever this log of engagement was provided to me by Victoria Willen on the 16th of July, most of these entries were blank, and she subsequently told me that they had to go in and retrieve old emails. So if there was a log that was a living document, why were there so many blanks in the statement of reasons or agreed facts?
Yeah, we have got a log of everything, but the logs didn't necessarily have the emails attached to it. So we went in to retrieve emails. I don't really see that that's particularly an issue.
But if
we have a log and it would have the dates, so we would know to go and look for emails for certain dates. And the council as a whole, you know, because if certain people have left, we then have to go and retrieve it in a certain way. So it's just not, you know, it's just takes a wee bit longer.
Yeah, but the fact is you didn't retrieve it because the statement of facts, the meeting or the alleged contact, 14th of June 21, no notes available. 30th of August 21, no notes available. 21st of February 22, no notes available. 6th of April 22, no notes available. Doesn't strike me as a completed log of contacts. That looks like a log list that's being maintained and accurate.
Well, I think we do have a log, and if there's we've got a log of all the dates the contacts were made, and yes, perhaps we should have had more notes on certain dates. I think the vast majority have got notes and emails attached that you've seen. Yeah, we do. So we do have the log, yes.
But it's not complete.
No, I think it's complete, but yes, it would have been better if certain dates had more information, absolutely. But
there's
a record of the dates that we've had interaction.
But there's no information on 4 of the dates. So how can it be a complete log?
Was there an answer to that?
Not that
Sorry.
I have.
I didn't hear that, then, sorry, I didn't realise.
And if there are 4 entries for which no notes are available, do you think the log is complete?
I think it would have been better if there had been more information, but this is information in the agreed statement of facts. So
Yeah,
as
confirm.
Stephen said, that there were interactions on these dates, you know, and that's not been refuted. That's in the agreed statement of facts. And yes, if you're asking me if it would have been better if there had been more information, yes, absolutely. But that's the log we have.
It's
And
not
I think
more
for all the-
information, it's
for all-
any
for all
information.
for all the dates and information, and the contacts, that is a complete log, yes.
Um, Don't see how complete log of the entries are blank.
Well,
but
but
I'm missing the point. I'll move on. I've actually found a number of other points of contact that Mr. McGill provided me with, where the council were in contact with Taylor and Fraser. And none of these are recorded on the log list. And would you agree that there's been difficulties caused by the retirement of 2 people who were leading on the project early on, Mr. Yardley and Miss Lowe, which has perhaps added to your difficulties in, pulling this log together?
I would say that we've got a statement of agreed facts and agreed contacts, and you've never mentioned any other interactions before just now.
No,
So
I wasn't. I wasn't. As I said, I wasn't aware of them myself until recently, because the council had never told me before about the contact with Mr. McGill.
Mr. McGill does appear on the log, yeah.
Yes, he does. He does. That's right. You point to the prohibition on advance purchase of the land in the council's love funding.
Mm-hmm.
When did you first raise this with Mr. Fraser or myself?
Only when we got to the stage of trying to see whether there was an ability to agree something in advance, and I explained how that process would work. I don't think our interactions before that and our engagement before that ever reached such a stage that we would have to discuss process.
So your view was it was always clear that there would be no advance purchases due to your funding restrictions?
Mr. Davison, I don't think we ever reached a stage or progressed to the stage in agreeing compensation that required any discussion on actual process and timings.
That's not the question I'm asking. I'm asking, you have restrictions on your funding in terms of advance purchases. When was this information made known to the objectors?
It'll probably be in the, I need to look up the log, but it was made known at the point that it was relevant to make it known. And it'll be in the statement in the log of engagement.
It was in July this year, but if I can refer you to TBF 20, which is an email from Margaret Law of the council, who makes no caveat about opening negotiations about non-binding terms. So, can you explain why she? Can we just
have a look at that?
She said discussion on compensation figures. Is that the one you're talking about?
Yeah.
Yeah. So I don't understand your point then. So why would she?
She's not caveat. There's no caveat there about we won't be able to purchase anything until after the vesting date.
Do we need to at that stage? Because all
Absolutely. We were supposed to be waiving objections, so therefore, as you'll know, you've referred to the fact that you've brought out objections before. These are done pre-CPO, pre-vesting, and usually on a voluntary basis.
We have done, but we've got a funding restriction here. But we don't always. I mean, I don't think there would have been any. And I mean, I can't put words in Mr. Taylor's mouth, but I wouldn't have thought Mr. Taylor would have wanted us to purchase half his yard if the CPO was never going ahead and the project was never going ahead. So timing and compensation, I think, are different things, and how we would actually. So Margaret has said here, we can discuss compensation, absolutely, and then if we get to the stage that we're nearing an agreement, we would then discuss the process of what would be needed from both parties, because I would imagine Mr. Taylor would need board approvals as well. That would be a natural part of the process. I don't think you need to agree the whole process and timings of boards and governance before we even start discussing compensation.
Well,
and that would be how we would normally do it with
I think you do if you're trying to buy out objections, then there has to be some certainty for the objector about what is going to happen.
Question, Mr.
But yeah, okay, right. When was the finalized design of the road completed?
And you'd need to clarify the actual dates with the technical witnesses, but I would think, not even, I would just be, my guess would be around about June 23, maybe, but again, I think you would need to clarify that date with.
Yeah, I'll clarify with Mr. Suarez. Thank you.
Because I work on a number of projects and I sometimes get dates confused between projects, so please clarify that. It's quite an iterative, ongoing process, design development, and so it's often not a date in the sand that you go, right, that's it done, because it's a kind of continual process. Even the junction design on Renfrew Road, for instance, is still being looked at currently. So there's different parts of design would be signed off at different stages rather than have a line in the sand. I imagine that's when the bulk of it.
The reason I asked the question is the aforementioned email from Margaret Law says that negotiations can commence from when the design is finalised. So what I'm trying to do is narrow down the window between when the design was finalised and when the council made its case for the CPO on the 14th of September 23. So that's what I'm trying to find out. But I'll take up that issue with Mr. Suarez. Thank you. Again, in terms of engagement with so people are treated fairly. I could refer you to TBF 18.
And is this an email from
Yeah.
yourself to Margaret?
That's right. It was what was happening is that council had served section 140 notices on the objectors and also on anyone else that they needed to carry out boreholes on. Can you give us did the council ever advise the those involved they could expect payment for these boreholes?
No, I don't think so. I think generally we, I mean, everything's reinstated. I would need to look up the Road Scotland Act for the section 140 to see what the actual legal position was, but I'm not entirely certain that anything other than reinstatement. So I think reinstatement would have been carried out. So I'm not sure what the position would be for.
The compensation is for the temporary occupancy of the land. You have the right to go in and do it. So what I'm saying was, asking was, did the council ever advise anyone, not just Mr. Taylor, because it was the next door neighbour that actually raised the issue to me first of all, that they were entitled to payment for these boreholes.
So I'm just that's what I'm not aware of this point being raised anywhere.
No.
The objector's evidence, so I'm not sure.
It actually has been raised. It's raised in the response to the objection of. Sorry, I think it's 1 second. The one of our early objection, objection to the scheme letter, I think 8th of January.
It doesn't seem to form part of any of the evidence to the inquiry. So
Beg your pardon?
It doesn't seem to form any part of the evidence to the inquiry. So it's not.
The inquiry is about whether people. My question is about. Did the council act fairly and reasonable? Did they, in terms of Scottish guidance, advise people of their rights? My inference is that they never told anyone the rights, so took advantage of people who were unrepresented.
This seems to be a different process, though, the question of boreholes, Mr. Davis.
But it is, but it's all for the same scheme.
So if the council had notice of this point, so we could have had documents, or we could have made evidence to respond to it, but this is not something sort of.
I think Mr. Davison is saying that this point has been raised. Can you show us where it's been raised, Mr. Davison?
Yeah, I'm just reading from my list of. I'm just trying to find it. Sorry to keep it.
There is a reference to boreholes. Just a second. In for document in response on behalf of Taylor and Fraser, dated January 10th, January 2024, which says, it's a response from Davison, and it says in the introduction, general I was not able to attend the meeting the council had, Taylor and Fraser, on 24th May 2023. Was not engaged to act with my clients when there were earlier informal meetings between the parties. I suggested these discussions were polite rather than positive, and I was extremely disappointed subsequently to learn the council had misrepresented what would happen when boreholes would be taken on site when I was engaged. Nothing was ever discussed in detail about the project. So there's a reference there. I think,
Yeah.
just from a search of the document, I think that's the only reference to boreholes.
I think it actually might be referenced in one of the council's core documents as well. But I think it's enough to rely on it there. There's an email between myself and Margaret Law on the boreholes.
We'd have to be clear about what was said.
Yeah, one second. Right, TBF 18 and TBF 19. Sorry, I've found my list.
18 we have open already.
And 19
is national. Oh, sorry, TBF. Yeah. 19. Well, to ask your question, Mr. Davison, and we'll see if Mr. Montgomery has an objection to it.
Okay. So those documents, TFB 18 and 19, are about the contractor issues and the council not telling people of their rights. So my point here is about engagement throughout the scheme and treating people fair and reasonably. So I think the question is valid and has been raised already in the board documents.
So I didn't understand the question, Mr. Davison.
Oh, sorry, I thought you asked me to explain why I thought the question was necessary.
Oh, I think ask the question. We'll see if Mr. McMurray has an objection to it.
With the two documents, do you accept that from the objector's point of view, the clients, before they were instructed to act for them, have not been advised correctly by the council, they could claim for in 140 cost?
Yeah, sorry. I don't want to. I don't think this. Well, it doesn't feel like it's a major point, but at the same token, the fact that there's a document lodged which makes reference to this, I think it's not really fair notice in terms of the point that Mr. Davison was going to make. The first mention of the Section 114 notices in any recognitions or not. There's no reference to that
As
anyway.
referred to in the earlier objection letter that Mr. Seaton read out. So it can't be a surprise.
Well, to be fair, that does sound rather by the by, the mention in the response to the council. I don't know. Rather than argue the point, should we just let Mrs. Walker answer the question?
I'm happy to.
I'm happy to give. I can't answer it fully without looking up the Road Scotland Act, but we send out. We do this. We do obviously site investigations for other major projects, and we send out Section 140 notices, which have standard wording. I am not aware that that there is compensation payable. If there is compensation payable, then I think I think obviously if there's damage done, any party would be we've got to reinstate. And if there's any damage done to the yard, we would obviously be liable for any damage caused. But I'm not convinced I don't know what the compensation would be, to be honest, unless we move them out the yard for days on end or something, which would be different. So but we have a standard letter that we've used on other projects for years and years, and this is the first time I've heard this raised. So it is very difficult for me to answer without going back and looking more at the wording on the letters and the Road Scotland Act, which I would need to go at in more detail. But I'm not aware of compensation being, other than for damage caused.
Thank you, Ms. Walker. Before you start, Ms. Davison, I think the question of whether compensation is available or not can be dealt with unless you have an immediate document that can demonstrate whether compensation is available or not for the making of boreholes. I think the question of whether it's lawful, whether compensation is required or not, can be dealt with in written submissions after the inquiry, because it's a simple matter of law, and you can refer to the precedent and statute.
Thank you. I'll do that. Thank you. You said in your recognition that Mr. Taylor, or that the objectors had declined to take up the option of the Gambian site. Is that a fair summary?
Yeah, I think you confirmed that it wasn't suitable. Yes, absolutely.
Would it not be more correct to say that it wasn't his preferred option because it was small size, but it might work if there were other land made available?
Yeah, I think you confirmed it wasn't suitable, and in which case, and when we agreed we'd leave it on the table, but you confirmed it wasn't suitable, and I said that there was no point in us going ahead and getting our consultants to undertake detailed design for accommodation works, unless it was something that Mr. Taylor wanted us to look at, and you confirmed it wasn't.
My question, would you accept that we confirmed it wasn't suitable if it was on its own that we would require other land to make up the amount that we were losing?
Yeah, you said it wasn't suitable because it wasn't big enough. Yeah.
On the proviso that we would need other land. So we didn't rule it out completely. It was still an option for us if we could get other land as well.
Perhaps I'm a bit, yeah, perhaps I'm not entirely certain. I know we agreed that I would need to look at the emails, see exactly what was said, Mr. Davison. But yes, I think there was an email that you said it wasn't suitable, and so I said that we wouldn't proceed with the detailed design on account that it wasn't suitable. But it's always been on the table. There's always been more discussions about if still available if we could make it work. Yes.
How would you say the council's resourcing issues have been during this process?
I think we've been adequately resourced. Yes, we've had a few challenges. That's been just, you know, every business has challenges when key people are, you know, unexpectedly or expectedly not in the team anymore, and so but we've always been fully resourced. When Norman was off, when Victor, you know, took over, and Victor was already working on the project with Norman, and before that, so and Colin was also working on the project before that. So I don't think we've had any major issues. There was maybe a wee bit of a crossover because when Norman left originally, it was without warning. So, you know, at that point, yes, it probably took us a few weeks just to work out where, you know, how to reconfigure Victor's other work so that Victor was clear for this. I think that's just standard. I don't think it's necessarily something that needs to be brought up in the inquiry, but it's fairly normal to change people leave. People, you know, that's fairly normal in any business.
I will up Mr. Seaton to find out whether my next question makes it relevant to the inquiry, I hope. And that, as you know, a large part of our case is the generally poor communication from the council and its slow communication. So if I could refer you to our email exchange of the 18th of July 24, that's TBF 23. Are you ahead of me? So in that email, you say we're very small.
Mr. Stephen, before you start, can I just ask about my understanding of this? I think I understand that the initial the initial message came from yourselves. The capital letters are Mrs. Walker, and the green letters are your reply to Mrs. Walker. Is that right?
That's right.
And the blue letters are what? Are they part of Mrs. Walker's response to your?
No, they're mine.
They're yours, right? Okay, all right.
Thank you.
Okay.
But let's say if I can read from that, there's two paragraphs which are in capital letters. We're a very small team with a lot of competing priorities, and we always act in good faith and try to attend to everything as quickly as possible. It may be uncomfortable to hear, but you are very tenacious with your follow-up emails, and it is clear to all that this is quite deliberate on your part. And then further on, we do not need to issue constant reminders. I don't think I have asked for replies within unreasonable timescales. And you use the word tenacious to describe me. Collins Dictionary, very determined and does not give up easily, which on its own is open to interpretation as whether that is a nice attribute or not. The use of the word deliberate, would you not, in hindsight, say that is ill-judged and shouldn't be something that should coming from someone in the public sector, and particularly in capital letters?
And capital letters were just to make it, for ease of reference, to make it clear what was yours and what was mine. So I don't think you can read anything into capital letters. I could have just as easily made them a different colour. I think after this, things were getting a bit heated. Yes, you were chasing and chasing and chasing. I do think it was quite deliberate, but I don't think that's necessary for us to go over. I think straight after this email, I then messaged you and said, could we maybe just have a chat? Which we did. We had a phone conversation, myself and you and Ms. Willen. And then because I kind of realised that the emails were getting a bit, everyone was getting a bit het up, including myself, but including you as well, Mr. Davison. So I think I took the heat out of it because I realised I didn't really expect you to raise it here. But no, I mean, I stand by what I said. But I do think that I immediately after this said, let's just have a meeting which we did. It's in the log what date that was. It was probably the day after or within a couple of days of these emails. And I said, take the heat out of it. And then we had a big long conversation because I felt at that stage a lot of things were getting misinterpreted by email, slightly misinterpreted. And so we had a big long conversation. I think we were on a call for at least an hour, going through all this. And I thought we'd kind of cleared the air and sorted it all out and rebalanced. Is my view of what.
Well, I thought I was talked over, and
Well,
I was a bit
can you
shocked,
leave that
but
for your evidence,
without-
Mr. Davison?
Pardon?
Can you leave that for your evidence without, unless you're going to ask that as a question?
All right. I'll leave it. I'll give you some examples of the reminders that I felt was necessary of the delays that have been consistent through the project. You refer to one in your.
If there's a question
response.
coming at the end of it, Mr. Davison, yeah.
Yes. Do you think it was reasonable for the council to take 8 months to get a plan of the potential Abercorn Street site?
Well, I'm not sure what you mean by the Abercorn Street site.
Sorry, beg your pardon, Excambian site. Thank you, Excambian site. Yes.
I'm not sure what where in the 8 months, what happened in the intervening period. I think again you would probably be better asking Mr. Suarez or Mr. Bathgate that in particular, because they would have been dealing with getting plans drawn up. So I'm sure it wasn't a case that nothing was happening during that 8 months, but I think you'd be better asking them in particular what was happening during that 8 months.
Right. It's again, it's in that same email exchange, TPF-23 between ourselves, and I can.
Do you want to find the location? Yeah.
Yes, I'm just second.
Right. So we've got it's near the bottom of page 6. An easy example is Mr. Taylor's trust to find his land. That's it.
Okay.
So, so I'll give you time to read that paragraph, and then you can.
Yeah, I do remember this now. And again, if you speak to Mr. Suarez and Mr. Bathgate, but yeah, there was a couple of things slipped through the net, and the plan was probably one of them.
Okay.
I don't think it impacted anything. I don't think it impacted anything that's happened since. I don't think that anything would have changed. It would have just been that, Harbour Road would have been discussed a bit earlier, maybe.
Surely it would have impacted immediately, we had known, because then Mr. Taylor could have ruled out, and we could have moved much sooner on to looking for an alternative. So we lost so much time in that period, and in the interim, you went ahead and submitted the case for the order. So with that amount of time, would you not think, as far as Mr. Taylor is concerned, when the clock was ticking, was actually quite important to him?
Harbour Road, I think you would need to ask the technical guys. And Mr. Bathgate is exactly what happened in that period. But yes, I'm not convinced that the actual plan, Harbour Road, is still there. It was there to see. So I think the size of it's fairly clear.
Yeah.
But yes, I accept that it would have been better if the plan had been submitted sooner.
Thank you. And again, in terms of, an example of frustration about the lack of or slow communication I can point to the agreed statement of fact. There was an email Mr. Taylor received 23rd of February 22, saying he was going to look at various sites to see if he could offer anything else to Mr. Taylor. Did he ever feedback on that?
I think we looked at sites, and we looked to see whether there was anything the council owned because in the area.
So when was that information fed back to Mr. Taylor?
Read facts here, which is quite small. I've read my eyesight isn't great.
Yeah, I'd have to try and. It said the 21st of March 24. So 2 years to get that answer. I think that's reasonable.
You took it just, it's not like no other conversations were ongoing, Mr. Davison. When you say it like that, you pick it out like nothing has happened in the interim. There was conversations ongoing this whole time. There was engagement ongoing this whole time. And until we knew exactly where the scheme was going and everything else, it probably, most of that period, it was probably not necessary to actually take that much further. You're acting like it was your question is implying that there was 2 years delay, but during that 2 years we didn't even have a design. We didn't even know in March 22, was that your first date, where the road was going to end up. So it's kind of linked to your question as to when was the design kind of finalised, and that's maybe the period that
this has got nothing to do with the design. It's just so Mr. Taylor thought you don't accept. He says he needed another site. The lack of urgency in getting the plan for the Excambian site, taking 2 years to come back and confirm you had nothing else to sell, suggests that the time wasn't of the essence to the council, and a slowness and lack of communication, which is not great.
I'm not sure what your question is, Mr. Davison, but I think that if we didn't know the exact final details of the scheme and it would impact Mr. Taylor, then I don't really see that it would be relevant to go and find other land at that stage.
Why?
Not quite.
Well, why was Norman Yardley then offering to do it in February 22? And if he wasn't going to do it, when did he ever, or anyone else from the council, tell Mr. Taylor?
One question, please. So should we start off with the first one?
Okay.
Why did Mr. Yardley do it? Offer to for land?
That's exactly demonstrating engagement, because we always engage with interests, and if there's a way of solving any potential objection before it happens, and so at that stage, though, unfortunately Mr. Yardley didn't realise we owned that piece of land. I'm not, so he confirmed that he didn't think that would be possible. And then Mr. Taylor had got his own solicitors sometime later to look at it and confirmed that the council did own the land. So that was unfortunate, but these things happen. And then we confirmed that yes, it was available and that Mr. Taylor could have it. We could discuss that.
I'm trying to move from a wider discussion away from one single Excambian site. Mr. Yardley was offering in February 22 to look for alternative sites. It took 2 years for you to come back and said you didn't have anything. So do you think in that circumstance that is reasonable period of time to come back with an answer?
I think that, as I've said, that the same 2 years when we were still doing design and everything else is not necessarily a fair question.
It was, whatever the design was, it was going to cut through Taylor and Fraser's Yard. Do you agree to that?
And I think it was always going to impact the yard, yes, but I didn't know to what extent, no.
Yeah. So Mr. Taylor needed to look for a plan B for his, in his view. I know you say it's not agreed. So he had to look for a plan B for his relocation site. So it was very important to him. So as far as Mr. Taylor is concerned, I think a 2-year delay to tell him he had nothing was reasonable, which has got nothing to do with the design.
And as I say, I don't think it was ever accepted that a relocation yard was going to be required, which is why we wouldn't necessarily go and look at other land during that period.
This has got nothing to do with the Scambian or whether the principle of a relocation yard is agreed in principle or not. It is the fact the council offered in February 22 to do something. It took them 2 years to say, give the answer, is that reasonable?
Can we see where the agreement is? What exactly the council agreed to do? Is that a document before?
Yeah, it's an agreed statement of facts. The 23rd of February 22.
Right.
Norman Yardley of the council advising the council does not own areas adjacent to the existing TNF premises, what not possible, but the council is looking at other areas owns and will feedback.
Okay.
I think at that stage, the what Norman was looking at was we were also doing we were in the process of purchasing the Shivas site for the new school, and that was still underway, and we weren't sure what land would be remaining after that. And I think we were hopeful that there would be some land in there that may well help, with engagement and avoiding objections and everything else. But yes, if that wasn't fed back, and it's not in the agreed statement of facts that it was fed back earlier, then but the work was being done. So I wouldn't so whether or not it was fed back, that was being looked at.
Okay. Yeah. And I'll just give one final example. Statement of facts, 24th of May, 23. And I will touch on this in broader detail with Mr. Suarez and Mr. Bathgate. But again, brief, there was a meeting.
Can you just repeat the date? Sorry, I missed the date.
24th of May, 23. So at that meeting, Mr. McGill handed over a list of how devastating the new road would be on the site of Taylor and Fraser's business. Made an action point to feedback. And to date, they've never done so. So it's over 2 years. So is that reasonable?
I'm just looking at this here. Where's the action? What's my favourite
It says it's about halfway down on the right hand side of column 2. VSCB sorry, no, lost this. Right, last line of first paragraph, and VSCB confirmed action to the review list and provide comments.
Well, I would suggest that you ask Mr. Suarez and Mr. Bathgate, since it's them that have the action, as to what happened after that, because I'm sure that they would have picked up the actions.
But there's nothing on the agreed statement of facts or in your evidence to suggest that they did do, as far as you're aware. I'll ask them later, but
yeah, I'm not aware of what happened after that, but
okay.
I wasn't present.
Thank you.
Do you have many more questions, Mr. Davison?
Hopefully not.
I'm just asking because we're coming up to 1 o'clock, and I wonder if it's appropriate.
No, I'm just speed reading these. Some of them are can be dealt with the other parties.
Take your time. Don't let me hurry you.
I think that, Mr. District valuer, I'm sorry to come back, but it's later in your recognition, so I've picked up on it there. Has said his view to date is that the current yard is extensive and significantly bigger than other similar businesses in the area. As not all industrial occupiers use the yard the same way as Taylor and Fraser might do. What exact similar businesses did he look at?
So I'm sorry, but just remind me what we're looking at.
In Miss Walker's recognition,
Right.
she going to retract that. I think that's in subsequent emails. It's not in the recognition. Right. Just, yeah, a second. I'm just going to do a word search on the recognition. 1 second.
Paragraph 8.3, just valuer view is that the objectors will still have a substantial yard after the CPO. Is that what you're after?
Which paragraph, Mr. Seaton?
8.3.
No, it's not. Just let me check the statement of facts.
Mr. Davison is at 5.7 in my recognition.
Thank you. Is that your summary recognition?
I think this is my recognition.
Yeah, sorry, there's two. There's a summary and the full one. Sorry, so must be this. Sorry. Thank you, Ms. Walker. You're right. It's 5.7. Thank you. Thank you very much. So there you say that it's significantly bigger than other similar business yards in the area. So on that basis, what other yards did he look at? Because my understanding So what other yards did he look at that he thought were comparable?
Don't know, I'm not a valuer. This was his advice back to me. I didn't get all the I don't know what else he looked at. This is his professional advice back to me.
But you say he reported, you had various
That's-
meetings with him and he reported his advice, so he
This is what
must
he
have.
reported. This is what was reported back to me. Yes.
And so, what, when he reported back to you, what made him come to that judgment?
Well, I think this is just his view that the current yard is extensive and that it was significantly bigger than other business. It was just a statement that he made, and it's currently used very inefficiently. That was his view from.
Would it be fair to say that if we looked at other similar businesses in the area, none of them actually do the same work that Taylor and Fraser do?
I couldn't answer that.
Are you aware of any other businesses in the area that do the same type of work that Taylor and Fraser do?
I don't know what all the other businesses in the area are, Mr. Davison.
You understand from our point of view how difficult it is, bearing in mind that information has not been passed to us by the district valuer. We picked it up from your recognition. That we do it from our point of view. Do you understand the frustration that we are not being told the basis of that?
I think the district valuer has asked for information, and I think you on the one hand you'd expect him to make an assessment without you providing specific information, and on the other hand you're saying that he's got no right to do that. He's kind. You need to. So he's in his professional capacity as a valuer. He's gone and done whatever valuers do, and this is his advice back to me. And if you have any information, or Mr. Taylor has any information that you want to provide to, we'll look at it. We'll absolutely look at it.
Well, we feel we have provided it, and we feel that the district valuer has provided absolutely nothing. And we're just trying to understand if he took this view without speaking to Mr. Taylor, myself, based on some unknown comparable business in the area requiring a yard of a certain size. So how are the objectors supposed to reasonably know the district valuer's mind if we only hear this information from you and it's never explained to us?
And it's probably the way I've written it, but I think what the district valuer is quite clear that Taylor and Fraser have a very big yard, and in the area other yards are smaller. I don't think he's made any assertions as to other businesses doing exactly the same thing. I said, he said other yards in the area but he's also said that it's currently used inefficiently.
Do he say similar business?
The site, he said it's been used inefficiently because it's it's been fairly empty on all his visits, and he's looked at Google Maps aerial and street view history, and he's had accounts of team members in Amy, and they visited the yard in the general area, and so I think that comment, I don't think he's compared the yard or other operations in the area to the operations that go on at Taylor and Fraser. It's probably just the way I've written this here. But I think what he was saying is it's a big yard, it's used inefficiently, and that in mitigation it could still be used if it was reorganised after.
My question, Ms. Walker, is what similar businesses was he referring to?
I think it was a generic comment.
So we don't know.
I don't even see that it's relevant personally. But what you're saying is it's a big yard. In that area, it's a really big yard. So he was just talking about the other yards on Harbour Road and Abercorn Street. Other yards aren't as big. I don't think he was particularly comparing to any particular. He's just saying he was talking about the background, the general area, and the kind of business you get in the general area.
And do any of these businesses hire in large cranes, have escorted vehicles coming in?
I think he was painting a background rather than looking at what happened in the yard. As I
But-
say, I think the way I've written it, I think he was just making a general statement about the area. And in this area, Taylor and Fraser's yard is bigger than other yards. I think that was all he was saying. This is a big yard for this location. That's all he was saying. I don't think he was trying to, say anything else other than that. And then and then he made the observation that on his numerous visits to the area, the yard was used inefficiently. I should have maybe made it 2 sentences. I think it's the way I've written this here.
Right. So there are no similar businesses in the area. Are we agreeing to that?
I don't know.
That we're aware of. Are you aware of any, or has the district valuer made you aware of any other similar businesses?
So
I don't think that's the point he was making.
I think that question's been asked already and answered.
the was answered.
I think we got the answer.
Oh, right, okay.
So,
We provided you.
Sorry, Mr. Davidson. I'm just wondering, like, if Mr. Davidson does continue with cross-examination, whether now might be a convenient time to break, or if he has much longer to go.
Well, I'm happy to take a break. I'm sure everyone would welcome that.
That's fine. So, well, we'll just resume following lunch then. Yeah. Is that okay, Mr. Davison? I mean, if you only have a few more
No,
questions.
that's fine. That's fine.
That's fine.
Yeah.
Okay, great. So should we come back at 2:00?
Perfect.
Great. Okay. Thank you very much.
Thank you.
Sorry.
I've returned, so I think we can bring once the council, once Mrs. Walker is back, we can recommence. But I think before we do that, we've received 2 further documents from Mr. Davison. Have you received those, Mr. McMurray?
Yes, I have.
Good, right, okay. So just in terms of those 2 documents, well, perhaps Mr. Davison can explain, just introduce them, and council can say what its position is.
I had mentioned earlier this morning the fact that the district valuer said he was restricted from giving me evidence by GDPR issues. So that's just the email from him confirming that. The other item is on the agreed statement of fact. There was reference to a 32-point list that had been handed over at a meeting by Mr. McGill of Taylor and Fraser. So as I'll be asking about that, I thought it's easier if everyone had a copy.
I was actually going to ask you about that. Yeah. So council, what position do you have on those 2 documents? Have you had a chance to have a look at them?
Yes, sir, and no objection to them being added to the list.
Okay. So we would make them. Hold on. Well, we better give them a document reference before we pass on. So they would be TFB
29 and 30.
29 and 30. Should we make the email 29 and the other document, the list 30?
Yeah.
Okay.
I found the section in the Roads Act, but you said I was to deal with that just in the final statement.
I think if you want to deal with that in closing submissions, yes, I mean that's fine to deal with that.
Thank you.
I don't think it's really. I mean, the law isn't really a matter of evidence, so I think you can deal with that in closing submissions.
Okay. Thank you.
Okay. So do you want
sorry to interrupt. Just
Yeah.
we don't think Mr. Taylor will be needed this afternoon, so can we give him the option of leaving us? Want to ask him, Mr. Seaton?
Well, I think it's for you to decide on how you lead your witnesses, but Mr. Taylor, I think we've agreed that that you won't be needed this afternoon. So if you don't feel you wish to follow the inquiry, but of course you are welcome to, you don't have to be here. I think you're muted, Mr. Taylor. You're muted, Mr. Taylor. You don't have your sound on.
Mr. Taylor, you put your microphone on. You've muted yourself.
Maybe looking for technical assistance.
Can't hear anything.
Yes, we can hear you now. Yeah.
Okay.
I'm not as familiar as you are in all the modern equipment. There we are. If you feel tomorrow morning would be fine, that would suit me fine. Okay.
That's great.
Thank you.
If I've got time later today, I'll come and sit in, but feeling that, we'll see you all in the morning.
Thank you, Mr. Taylor.
Thank you very much. Thank you.
Mr. Davison.
Thank you. Mr. Walker, you'll be pleased to hear there's only edited my questions down, so there's only a couple more to go, so we're almost there if you bear with me. The first question is, how is the council factored in the risk that without a large yard, the business might have to move premises and possibly out with Renfrewshire?
I don't know what you mean. Do you mean how we quantified our kind of risk budget, or do you mean?
It's just there's been a discussion about the potential if the impact on the business is severe as Mr. Taylor and his advisors allege. How is the council? What is it doing to bring in mind that risk? How is it?
Well, we always have, for all our projects, we always have a quantified risk register. So any risks like that would be included in a quantified risk register. Certainly, if you're asking me, do I believe in this case that's going to happen, then no. The advice I've had is all pretty clear. And the advice I've had from the DV and from the technical advisors and everyone else that that that's that I do not. I don't think there's a huge risk Taylor and Fraser moving out with Renfrewshire, if that's what you're asking me. But yes, anything like that is included. We have a quantified risk register for all our projects, and we would have a range of likelihoods of risks that were project specific. And I suppose that's what you would be referring to here. But yeah, I mean, we wouldn't want that to happen. We absolutely wouldn't want that to happen. Obviously.
We obviously have a slight impasse at the moment in terms of we don't have fixed tender costs yet for the potential relocation yard.
Mm-hmm.
But getting it as a side, would you accept that the potential cost to upgrade the relocation site would only be a small fraction of the cost that it would be to relocate the business? I'm not asking you whether the business is a case proven as to whether the business needs to relocate. I'm just asking you to comment on the cost to upgrade a yard versus relocation.
I think, I've said we'd pay £1,000 towards getting tender costs so as we could see what these were. A business relocation, I would have no idea how that would be quantified. I would need to ask advice from the DV. So, but yeah, I don't know that answer to that. I could make a guess, which is what you're trying to get me to do, clearly. But I don't actually have any knowledge of exactly how much it would cost to relocate. And I don't have any knowledge of the upgrade costs because the tenders aren't available.
No, but presumably the district valuer has given you advice on the worst case scenario for a relocation.
He's given me advice on what he believes the position to be, yes.
But so he's never commented on the potential costs.
He's commented on all the different things that the objectors may want to lead, but there's not been any evidence or any suggestion that is a possibility. So I think that's where we're at.
Sorry, I mean, it definitely feels that these are very much pure compensation factors.
Well, they are and they aren't, but you'll be glad to hear I'm virtually exhausted on them. In the event the business did have to relocate, how do you think they should be received in Paisley?
I don't think that's a position we want to be in, and I don't think I think it's pure speculation, Mr. Davison, at this stage. I don't think that's going to happen. I firmly don't think that's going to happen. I don't think that's necessary, and I don't think there's anything to suggest that might happen. So I think you're asking me to speculate.
I would
rather not do that. I don't think that's my answer. I don't think there's nothing to suggest that's going to happen.
Well, obviously from our side, we disagree, and all I was trying to say is, on a risk assessment of that, I would ordinarily expect to be a comparison of figures. So you could factor in the risks of that, the additional costs of this lands tribunal reference or whatever. So I just, but it seems it hasn't been done, so I just have to park on it.
The district valuer has given us advice on all the different potential heads of claim that you may wish to pursue. But on account that he thinks that his view is that that's a relocation isn't going to be necessary, I haven't expended public money on getting him to do a valuation of what that might be. If that's not necessary to do at this stage. But that doesn't mean that we're not aware of all the potential scenarios. He has provided advice, but he hasn't done a formal valuation of Taylor and Fraser relocating out with Renfrewshire. I don't think that's been necessary.
It's up to the council to decide whether it's necessary. I'm just trying to find out what risk assessment the council has done in the worst case scenario. But that's me finished my questions. Thank you very much for your time.
Okay, thank you.
Okay, may have some questions I've got. Sorry. Sorry, just for my own understanding. Obviously, you're saying that the business case for the LUF funding, for levelling up funding, it's not been signed off. Can you just tell me about basically the procedure and what circumstances it might not be signed off? Well, start with that.
We go through when the original LUF call for round one of LUF, I think we got something like 12 weeks to pull together a submission, which we did, which is more like a kind of strategic business case. And then over the next, once we got that approved and we got the funding approved, it was subject to having an outline business case approved, which we worked on. We appointed Amy, obviously, and we worked on this over a couple of years, and that was approved. But we have one final stage, which is final business case. And generally, this is the same process we use for other city deal projects and everything else. So you go through this SBC, the OBC, and then the final business case, the FBC. And when you get to FBC, provided the OBC is where most information is. So when the OBC is signed off, provided you don't make any major changes to that, and the FBC, I mean, I'm making it sound quite simplistic, but you more or less add in the tender price, and then you've got your funding, and you've got as long as there's no changes, it's a kind of process like that. So it's more or less a nod to sign it off. It shouldn't change significantly from the outline business case, other than you won't know the construction cost. So we would go for FBC approval after the construction cost was available. So, and we also have, so, and the way that this process
Which
works.
would include the costs of the compulsory purchase, presumably. No. Yeah.
No,
of course.
So this would be the construction tender. Our other project costs, yes, certainly our other project costs would be in the business case, yes, but the actual construction tender costs we would need to know before we went for FBC approval. But the FBC, yes, correctly, it includes all the project costs, not just the construction costs. So we'd need to have all that before we could go for FBC, and we need FBC approval from Levelling Up Fund and also from the council. And then it can be a bit of a nightmare governance wise, because we also need a separate approval for the construction contract that goes to our Finance and Resources Board, but the actual final business case would go to our Economy and Regeneration Board. So we need to kind of line everything up, but we need all these approvals in place, and we wouldn't ever award the contract unless we knew we had the land. So we wouldn't proceed unless we knew we had the land. So if we made any major changes to the business case between OBC and FBC, there would be a risk it wouldn't be signed off, and the funding wouldn't be, forthcoming.
And in terms of the compulsory purchase order, vesting will only take place after the business case has been signed off, presumably, obviously.
Yeah. So vesting, so we would time that all up. So we would have so when we get the business case signed off and the construction contract awarded, we would try and, because I think it's usually 12 weeks is for vesting. So we try and have everything teed up so that when the construction starts on site, we have the land. I mean, it might be, there can be some access for for setting up site cabins and whatnot. But yes, basically we have to time it so the vesting period has ended in time for the contractor to get free access to the land that we've included in the contract with no restrictions.
And the accommodation works take place presumably only after the land is vested. Well, I guess obviously only after the land is vested. So there is a bit of time between the minister's decision on the compulsory purchase, or potentially a bit of time between the minister's decision and the point at which you'd be looking to sign off the business case. Is that right?
I mean, ideally, we would want to. We're aiming for to get our contract awarded to start on site before the summer next year. So we would need to kind of look at the timings. We have got all this mapped out, but the timings so that we've got each approval at the right time. But yes, the vesting process, we'd probably risk awarding the contract if the CPO had been confirmed, but we wouldn't actually start on site until we had the land, because obviously the contractor can't access the land, and then that would leave us open to claims that they would say, we thought we could get in here but you can't yet because the vesting's not complete. It can be a bit of a we map it all out once we know what dates and what the dates of the boards are and everything else. Yeah.
Okay. Now, in your statement, in the council statement, please, I think you refer to this in your recognition as well. Council say that they would be happy to enter into a legal agreement with suspensive conditions with objectors, including Taylor and Fraser. Can you just sort of outline what that would involve? I mean, is it what exactly would the suspensive conditions be?
It would basically be vesting. It would be on the CPO being confirmed. So if we were entering into a legal agreement, say with Taylor and Fraser, because that's who we're discussing today, we could agree compensation as long as I had a figure. And my problem at the moment is we don't have a figure. I need to go to board if it's done on a voluntary basis. We have to go to it would be, we've got all these different boards, but for land it would be Infrastructure, Land and Environment Board, and I have to go there for an approval to enter into the missives. And so we could enter into the missives, and the missives would say, I mean, they could be binding other than, binding provided the CPO was confirmed. Because at that point we would then proceed to, purchase the land on a voluntary basis. But I would have to go to board, because it's a voluntary kind of land transaction. That has to have a board approval. Obviously, sorry.
So you can do that within the rules of the LUF funding. You don't need a clean title.
Yeah, so we would. Well, I think we would. Presumably, we would still have a clean title because our solicitors would be all over it. But yes, we could do that. We could do that in terms of the LUF funding. We just couldn't purchase the land until after the final business case. So that would all be kind of timed. So we need the final business case signed off and vesting. Our CPO confirmed it, so we could have a date, that the project's 100% going ahead, and therefore we would purchase the land. And I would need that to be very clear in the board as to the timing of that.
Okay. Just one last question I was to ask you was just in terms of the offer of money, £1,000, I think it was, for Taylor and Fraser to obtain tenders about the Abercorn road site. But when was that offer made? Do you recall? Or is it down in the?
I think it'll be down in the
timeline.
The timeline. It was after I had the meeting with Mr. Davison. Right. I'd said, well, to be helpful, then could we at least move that on and see how much,
right,
and have and consider
so that was maybe July this year.
Yeah, maybe July. Yeah.
Right. Okay. Grand. Okay, thanks very much. I think Mr. McMurray may have further questions for you.
Thank you, sir. I will be quick. I'll have a couple of very small points. Just one building on the reporter anticipating what I might ask, I think. In relation to end of paragraph 3.11 and paragraph 312 of your full recognition, Ms. Walker. I think that's where you summarise the conditional agreement.
So we're on a 3.11. 11.
Yeah, so the last sentence of that and also paragraph 312.
Yep. Mm-hmm.
Yeah, I wasn't going to ask you to read that, but I think that's where you're setting out how the conditional agreement may work. And I was just going to ask you how that compared with your experience on other CPO projects that you mentioned in your evidence.
We've done it different ways, but yeah, we have entered into legal agreements previously with other interested parties, not necessarily objectors. And in one case, and we didn't have conditions on funding with prior purchase of land. In one case, for the actual AMID site, which was we had decided that to de-risk the project, we needed to buy the whole area of land in advance. We did advance purchase that, but we got approval from the council board to do that, and that was through City Deal funding, so we got approval from City Deal as well. It really depends. Other ones, yes, we've gone and had. I think on the CWR project we had we entered into legal agreements, but we made it conditional on certain point in the project, whether it was vesting or planning, or we didn't enter because we had to obviously be careful that we weren't buying land that we weren't ultimately going to need. So we have entered into agreements like that in the past that are that we have everything agreed up front and have the board approval, but it's conditional on planning being granted, or the CPO being granted, or the final business case being signed off. And so it's not completely unusual for us to enter into agreements like that.
Thank you, Ms. Walker. And the final point I was going to make, if you go to the statement of agreed matters and the timeline again.
Mm-hmm.
I think Mr. Davison had asked you about a 2-year period for the council to look at other potential areas owned by the council for Excambian. But perhaps if I could take you to an earlier entry in that table, in the 12th of January 2022.
Yep.
On the end of the second paragraph, there is a statement saying that there's a preference for Taylor and Fraser to gain land at Harbour Road.
Yep.
And then the entry that Mr. Davison was focused on noted that the council did not own the area adjacent to Taylor and Fraser, which I assume to be Harbour Road, but the council was looking at other areas.
Mm-hmm, mm-hmm.
And then in November 2022, you can see the last paragraph of that, where I think it's saying that essentially Mr. Taylor had noted that his lawyer had determined the area was owned by the Cart River Trust, which I don't know how that goes through statutory derivation or something, is now the council. I was just wondering if you could comment on taking those 3 entries, why there might not have been a report back on the alternative Gambian sites.
Well, from looking at this, I'm assuming it's because we were particularly looking at Harbour Road, and because that was always my understanding, is that's what the preference was, and I think Harbour Road we needed to check. When Mr. Taylor's lawyers came back and said we owned the Solum of the road, and Harbour Road is slightly wider than the Solum, and I think various other checks were being done during that period, and so. Perhaps we didn't feed back enough to on what we were actually doing, but I think my understanding is this was discussed, at meetings with Mr. Taylor and our technical team, and we had our in-house solicitors looking at the wider titles in the area.
Thank you, Ms. Walker. I have no further questions.
Thank you.
Thank you, Mr. Walker. So I think it's for Mr. McMurray to call his next witness.
Yes, the council's next witness will be Mr. Suarez. If you could just give us a couple of minutes just to get the room set
course.
up.
Should you just give it 5 minutes or so?
Yeah,
2:30?
we should need that. Yeah, 2:30 would be great. Thanks, sir. Ready to go?
I think I said 5 minutes, so perhaps unless Mr. Davison is there. He is there. He's there, I think.
Hello again.
Oh, well, we can make a start if everyone's happy to go now.
Thank you, sir. Good afternoon, Mr. Suarez.
Good afternoon.
Perhaps if you could have your full recognition in front of you and your summary recognition. And if you don't mind, I'd ask you just to read the introduction and qualifications on your full recognition, and then your summary recognition, if that's okay.
Yeah, that will be fine. I want to start with my introductional qualifications, if that is okay with everyone. My name is Victor Manuel Francisco Suarez. I am a BSc in Honors in Civil Engineering with Environmental Management and a member of the Institution of Civil Engineers, and I'm a member also of the Association of Project Managers.
My role is project manager from the Advanced Manufacturing and Innovation District of Scotland, AMIS South Scheme, the project. I started to work on the project in 2022, and my role involved the planning, execution, monitoring, and controlling of the project. My duties include coordination of resources, managing of budgets, measuring and tracking of project progress, and communication with team members, stakeholders, and external consultants. An experienced project manager with over 19 years experience in program project management, design of buildings, civil and structural engineering projects in rail, private, and local authority sector. Responsible for programs and projects from inception, business case stage, through feasibility, detailed design, site supervision, and up to contract completion. I've not been involved in any compulsory purchase orders processes previously. However, I have been involved in projects where a complex land negotiations were required. For example, Cambridge North train station, where land was required from 3 different landowners. And now I go to my son.
Thank you, Mr. Suarez.
AMIS South is a project that has been in development for a significant number of years. Started in 2019, and the aim is to provide a link between Paisley Town Centre, Glasgow Airport, and the new AMIS development. It was identified as an opportunity to regenerate a prime area in central Paisley, which at the moment is an industrial estate. The project will offer great opportunities in the future in terms of regeneration of the area. Council representatives have maintained an open dialogue with the objectors through the development of the project. There are record ongoing conversations since 2019 involving both parties, and likely TF agent as well. The selection of the proposed route has been based on several factors which are explained in the outline business case and the associated documents and appendices. These documents explain the selection process of the route and the key elements that have been taken into consideration when the route was selected. The Council has explored options to offer an escampion land in order to mitigate the impact in the Taylor and Fraser Yard, including a possible area located in Harbour Road adjacent to the area. In order to support this escampion land proposition, the Council confirmed that any cost involved in making the land suitable for Taylor and Fraser will be assumed by the Council. The benefits of the project include the improved transport links for all the businesses, reducing traveling time and accessibility, health benefits with reduction of pollution, and the construction of new active travel links. The trail route from Paisley Centre to the airport and beyond will improve the accessibility and the transport network, and it will serve as a catalyst for regeneration, creating additional new opportunities. The proposals will deliver an improved road network with associated active travel facilities, as well as opening new opportunities to regenerate the area. 2 suggestions have been made to the CPO concerning the purchase of part of the existing working yard of Taylor and Fraser, and this issue has been considered and response has been provided.
Thank you, Mr. Suarez. I know you were obviously observing the evidence earlier today of Ms. Walker, and you'll have seen and heard that Mr. Davison was asking questions around a meeting that you were in attendance at, and that's referenced in the statement of agreed matters, the timeline, and also is now the list that was referred to in the timeline has now been lodged as TFB 30. Do you have any comments you wish to make around the record of that meeting and the list that has been submitted?
With reference to the list, it's a suggestion that we needed to go back to the Taylor and Fraser. During the meeting, all the 32 points were discussed, and they were mainly in concern to different elements of the project. The compensation element, that I'm not an expert, I couldn't really discuss that matters, and the technical element. The technical element, we promised Mr. Taylor and Fraser that we will look at all their concerns and incorporate them to our design. So that's what we did. So we didn't really maybe put down writing but it was agreed beforehand that that was the purpose of Mr. McGill providing to us the 32 points. Okay, and some of these points, as I said, all the points were almost discussed during this meeting, and I'm concerned, for example, about drainage and concerns about different elements. And we basically said we look at that. That is part of our design. That is part already has been taken into account in our design. That is how we design a road. So that is basically it. The other elements are more compensation matters, and at that point we couldn't really discuss that or even provide an answer, to be completely honest. With respect, one thing that concerns me, and I don't have the same recollection that Mr. Davidson, is that at the time that I met him, I think it was, Mr. Davidson seemed to suggest that I agree that the yard couldn't work if we take the proposed land, and that is not correct. I can actually assure you that I said, yeah, in terms of land, Taylor and Fraser is probably the most affected business. There is no recognition of they couldn't work, they couldn't continue the business in that case.
Exactly, Mr. Suarez. That's helpfully answered two of my questions there in one. Very efficient. The next question I had for you in terms of there have been some suggestions in the evidence of the objectors that your council didn't take time to ask about the business operations or to understand the business operations of Taylor and Fraser. How does your recollection fit with those suggestions?
My recollection is in every meeting, at least I have been present. We have asked then of any how the yard will work and any other requirement. If you look at the 32 points, we already have addressed that in our design. So the thing that confuses me is until the meeting, I think it was the 14th of September, no, the first couple of weeks ago, we never had no knowledge of the working practices in that amount of detail and until then. So it would have been very helpful if we get that information maybe slightly earlier, because we will have enough time to consider it.
What was the date? Sorry, in August.
Yeah, that was the day that when they presented when the reporter, Mr. Seaton, came on site. That is the first time that I have seen that information. And my design team, as far as I know, is the same.
That's great. Thank you, Mr. Suarez. And finally, before I'll hand over to Mr. Davidson, who I'm sure will have some questions for you, if I could ask you to have a look at document TF-24.
Yeah.
And just interested to comment on how these photos align or otherwise with your experience of the site.
Let me look at all of them, please. Yeah, that seems to be what every single time that I have been on site, I have been able to look at. I have never seen the yard as busy as last time that I was there.
The last time you were there, that would have been the site visit, or?
Yeah, that was in the site visit.
Thank you, Mr. Suarez. I have no further questions, and I'll hand over to Mr. Davison.
Mr. Davison.
Thank you. I'm going to refer you back to the photographs you've just seen at TBF 24.
Yeah.
I provided those just to show how what was stayed on site was always fluid. It moved all around the yard. There's some days there's actually nothing on it, and some days there are other items. So how do you address our point that the yard was fluid, and a snapshot in any single day is not representative of the potential, the use or potential use of that yard?
To know approve or I can approve either ways. The only thing I can tell you, Mr. Davison, is that every single time I have been on site, the yard has been lightly used to see. Okay, the same experience has been by the the same situation has been with the designer, because as a matter of the in our designs, we visit the site every, not only a specific the Taylor and Fraser site or the whole project site every 2 to 3 months to check that things haven't changed, especially in a project of this nature that it takes quite a long time to progress from where you start your your process at the beginning to how you get until the later stage of the detailed design. As Barbara was saying, I'm sorry, as Mrs. Walker was saying, yes, earlier on, this is an iterative process. You cannot actually set a design and do it. You just do it in one go. It needs to be up to a certain degree. Up to a certain degree, it needs to be checked against different parameters to get the right answer, as at least in engineering terms.
And in your time being there, have you noticed any difference between the use of the east yard, which is to Abercorn Street, and the west yard to Harbour Road?
Only in the latest 2 meetings, in the latest visits, more elements on the west yard has appeared. The east yard seems to be always cabins. I haven't seen anything else.
Would the whatever's stored on the east yard be generally stored around the periphery, like in a U shape on the yard? Most of it being vacant?
Most of that is probably vacant, I would say.
No, but would there be at the boundaries? So basically, would they store their things you've seen on the eastern yard? Would they generally be stored in a U shape rather than across the whole site?
A tiny bit of both. Sometimes they're in the middle, sometimes they are in the side, for what I can remember.
Right. I'll come back to that. Thank you for that. Well, I've referred to you attending meetings in December 23 and February 24 at Scott and Taylor's offices. We obviously were talking about issues that were valuation matters. So anything you referred up to that we had raised, you referred to your in-house surveyors at that time?
Sorry to hear you properly. I missed you there.
Whenever we discussed matters that were valuation issues which were out with your field, particularly the meeting of 19th of December, did you escalate those to your in-house surveyors?
I basically said that our own in-house staff will look at any matter, and we will discuss that with Mr. Taylor and you at your time. I don't have any other. I'm not a specialist in valuation matter.
Fine. In the statement of agreed facts, if I can refer you to the meeting on the 12th of January, which I think predated your involvement.
Predated my involvement. Okay.
Well, were you not, thought you came on board in 23? No?
Yes, for 23.
I wasn't trying
Whatever I was involved in certain elements.
All right, sorry.
That.
My apologies. You weren't at that meeting, but the notes clearly say that the business is going to need other space to store plant elsewhere. So, what actually happened following that in terms of advising Taylor and Fraser what to do?
Yeah, if you allow me to look at the statement of reasons. What date did you mention, please?
21st, sorry, no, 12th of January, 22.
Okay. Yeah, 22. And you're referring to the second or the third paragraph?
It's the fourth last line, PS, which should actually be ST for Scott Taylor, noted, depending on the project they have at the time, they may have to store plant elsewhere. So what did you think he meant by that?
I don't know. The only thing I can say, depending on the size of depending on the project, they may need to store plant somewhere else. The intent of that comment, really don't know because I wasn't present, and I think it's quite difficult sometimes to get the whole tone and nuisance of the conversation through notes from a meeting. So I don't know, to be completely honest.
Right, okay, thank you. Again, I did ask this question to Ms. Walker, but I'll ask you again because you were closer to it about the description of the land as being unused. So, can you
was
explain?
Was that description by me?
It's a second.
So it's in that meeting of 12th of January, and I think it's subsequent, a subsequent meeting, there's a reference to it. Is that right?
12th of January 2022.
And 30th of December, yeah, that 2022. So 12th of January and 30th of December, of November, sorry.
My guess, and it's only a guess, I can only give you my guess because I wasn't there, and I didn't never use that. Use a word. It's just basically very poorly explained areas that they are not occupied at the moment. That's the only thing that I can say. Saying that, with a significant areas, every single time that have been there, they were not occupied.
There you are. Just unlucky. So on the 22nd of June 22, on this agreed statement of facts, Taylor and Fraser objected to the planning application, saying that the yard was integral to their business. So again, once again, I'm building a picture of Taylor and Fraser telling the council how important the yard was to them. So why did it take until 30th of November 22 before anyone from the council actually went back to them?
Again, it's a kind of the project I wasn't involved with, so it's difficult for me to reply to that. I'm not involved in this matter, that's for sure. I was more like a technical technical elements of the project. So my understanding from conversation with Mr. Jarley is that the JAR, no point Taylor and Fraser has shown or demonstrated that the JAR could not work. And they even in meetings later, in discussions with Taylor and Fraser, it has been always the case that obviously it's going to affect Taylor and Fraser, but nothing was in terms of, oh, we cannot work together, we need to relocate. That's my recollection of it.
So we have no reason to claim a 5-month gap before anyone.
Well, the only thing I can tell you is when certain elements, when there are certain periods of time that we maybe not provide an answer, is because we are doing some iterations to the design or looking at another consideration that we could take forward. That specific period of time, I cannot really tell you.
Yeah, Ms. Walker deflected the questions onto you, and I'm passing them on to you, and you're not able to answer them. So we just wrote an explanation as to why there's this gap.
So there's only one person that has been here since the beginning, and it's Mr. Bathgate. So a lot of questions that you answer me are outside my time frame. You answer me, and I can answer the ones that are related to my time frame quite nicely.
You're going to step, of course, Mr. Taylor was there as well, so he can answer them.
So can I just, sorry to interrupt, but can I just clarify, Mr. Davidson was referring to a gap between, is that a gap between the planning objection?
Yeah. So the planning application, the objection to the planning permission went in on 22nd of June, and then the next time there was any discussion about the issue was 5 months later.
Thank you, Mr. Davidson.
Thank you.
My guess at that point is that because a planning stage, you don't have a detailed design. You only have a kind of outline design that gives you enough information, gives the planners enough information about the requirements of the scheme. Where you actually develop the scheme properly in terms of detailed design, that sometimes can take up to 2 years, is later on, and it's after planning has been granted, because basically what you're getting is the basic principles agree with planning, that it complies with planning regulation. And that also allows us to be able to send that information to introduce that information into the OBC and send that information to and full business cases as well, and FBC, and send that information to LAF for approval. Because all the design needs to be approved by LAF. It may be a tiny bit of explanation here about what LAF is. Apart the level one is the people taking the designs will be people like the DFT, which are agents of the active traveling.
But I think if we stick to the questions, Mr. Davis is asking.
Okay. This one, hopefully you'll be able to answer more, because you were at the meeting and you had a couple of questions from if you're recognition on it. But I can take you back to the meeting of 24th of May 2023.
Yeah.
So we are agreeing that you were tasked with Mr. Bathgate with reviewing the road layout, minimize the impact that the proposed design would have on the yard?
Yeah.
Okay. And you talked about provision of accommodation works and fences, which would be a valuation matter when Mr. Taylor wasn't represented. Accommodation works are part of the compensation and therefore a valuation matter. So you were talking about a valuation matter.
No, well, I cannot really tell you one way or another because I am not an expert of valuation. So what I can tell you is what we discussed during the meeting. I'm quite happy in telling you that. And yep, we discussed the possible accommodation work, and we said, well, where is the best location for you? Do you need any special requirements? And can you let us know what is this?
No, I was just trying to establish accommodation works for a valuation matter were discussed when Mr. Taylor wasn't represented.
Sorry, I don't think that was accepted by Mr. Suarez.
No.
I said no.
Well,
I
I'll rephrase.
requirements of Mr. Taylor. I specifically asked Mr. Taylor what he needed, if he wanted to provide that information in terms of project development and making sure that we continue with the goodwill of trying to accommodate as much as possible to Mr. Taylor. So I asked them what they needed. If that, I don't think that's a valuation matter, in my opinion. But I thought no.
That's I don't think it's solely a valuation matter either.
No, it's.
No, I don't think no.
Sorry, you're saying it is or isn't a valuation matter?
I mean, accommodation works don't seem to me to be solely a valuation matter, unless I may be mistaken about that. But is that what you're saying?
Yeah, accommodation works are part of the compensation and evaluation matter. They're there to if they weren't provided, the claim would be more. So therefore, they are integral to the valuation.
Matter submissions.
I'll give you an easy example. When surveyors were looking for their fees in the old days, you could add the valuation of the accommodation works through the compensation so that your fee was on a higher rate. So they've always been part of the compensation and valuation.
To discuss that, but what I can say is that the council actually all the cost of the accommodation work, we assure Mr. Taylor that it will be paid by us, and we have already agreed to that. So, no.
So at the meeting, both yourself and Mr. Bathgate received this list of concerns that the bullet points. They were an email to you, and Mr. Bathgate who acknowledged receipt on the 28th of May. So what actually did you do following receipt of these bullet points?
We review all the points, the ones that could be, and we accommodated the majority of the points into our design, because when we have the time to do it, that was our last chance. It was concerned, for example, if I remember well from the top of my head, about drainage issues. We address that, and we address a significant number of elements in terms of design. In terms of other issues, they were all compensation evaluation issues that I have no knowledge.
Both you and Mr. Bathgate had an action to review the list and provide comments.
We have,
as far as I'm aware neither the council or Amy ever responded to Mr. McGill.
I don't think we have. I don't recall to provide comments. I do recall having to review all the issues and try to make sure that our design actually comply with them or try to accommodate the majority of them. I don't recall that, but
Could I refer you to the statement of agreed facts of the 24th of May 23, where it's an action point for the two of you to feedback. So that's the last line of paragraph 1. VSCB confirmed action to review the list and provide comments. So
that was not my understanding.
That's come from the council's own notes.
And it's been agreed by the council.
Yes.
And it's been agreed by the council.
Yeah, but I was certainly that's not what we did, but the whole idea was to review the comments and incorporate them into the design. And my recollection is that we agreed with that with Mr. McGill during our conversation, and Mr. Taylor was there too.
Well, you say you have this action point, but it's not what you did.
Maybe the only thing that I can say is that we review all the comments and they were introduced into our design.
Was that?
If I miss, I need to go back to Mr. Taylor, or we missed that, which may be the case. But everything was action as required and as agreed.
It can't have been actioned as required if your action was to go back and discuss it with everyone before.
Out of the 32 points, all the technical points were considered in our next stage, design development.
Considered and discussed with whom?
With the designers, which are the ones capable of actually taking that into consideration and moving that forward to be able to make sure that the yard doesn't get flooded any longer, for example.
Right. So they were they discussed with Mr. McGill?
They were discussed during the meeting with Mr. McGill? Yes.
No, after your action point was to review them. So did you review that and feed back to Mr. McGill or indeed Mr. Taylor?
No. That was not my understanding.
What?
Oh,
it is agreed in the statement of facts that was your action point.
The thing that I will say, it was not replied formally, but every single time that we have been in the following meetings, we actually were able to show the change in the design, and we were able to actually tell them, look, this is what we have done. Okay, in order to accommodate you. But formally, no.
Who were those changes discussed and when did it happen?
Happened in, I think, was between that time and probably June 2023.
So are we talking beginning or end of June?
Most of them, so I think so, probably towards the end of June.
End of June. So the finalized design was effectively established by the end of June.
Yes, with a couple of caveats. When I say finalized design, it's the elements around the as far as I remember, and I'm not a designer, that was where the layout was more or less agreed, subject to final reviews. Final reviews were done by Amy, and then from that point, that's where we move forward into doing the CPO.
The final design was reviewed not by, it wasn't run past Taylor and Fraser. Before the decision was made to go with the final design, was that run past Taylor and Fraser for their comments?
The comments were provided in that 32 points in the previous design. So we took that 32 points and we moved the design in that way.
So, sorry. In the changes that you made, did you go back to Taylor and Fraser in any way, shape, or form, double check that your revised design was in any way getting them out of the problem that they faced?
No, because we took that into consideration. So there are a lot of the comments were to minimize the amount of land that we were taking, and we did that, which is basically the main key issue that time for that.
I'll move on. We can go through the list and we can then, if you don't mind, the one I emailed earlier, and just to go through it. You may defer some of these to Mr. Bathgate. So on the first one, I'd like to bring one is the third column of number 1. There'll be restrictions on heavy deliveries and departures. So what happened? Restriction on heavy deliveries and departures.
Hold on, Mr. Davison, just so we understand what's in the list before you do that. The way I understand it is that the first column shows a problem.
Yes.
The second column gives a description of the problem. And
I think the fourth one was a risk.
I'm not sure the risk is in the third column. Yeah,
I think the risk is the third one.
So surely the risk relates to the particular matter raised in column 1. That's the way I read it. Is that?
Yeah. Yes.
Is that the way you read it? Right.
Yes.
Okay. Right. Right.
So, how did you address the Taylor and Fraser concerns about restrictions on heavy deliveries and departures?
Which one is that?
It's the first one, the third column.
Column or third line?
The first
Third column, first line.
Yeah.
Let me find it because I got that in and I cannot do it. So
It's the problem of a printed copy. Are you printed on both sides, Mr. Suarez?
yes. If you can open my emails, I'd probably be able to find it better.
That might be easier, yeah.
Okay. Access to build, is that the one that says access to building to the new road and entrances will need significant logistical planning?
No.
That's my first one. That's in your document, Mr. Davison.
It's the first one I think Mr. Davison is referring to. The access from Harbour Road will no longer exist.
Yes.
The description, the main route for heavy vehicles deliveries will be changed several times, impeding our daily business, and then the risk is described as restriction on heavy deliveries and departures.
I cannot see that.
It's the on the
First
hard
page, second page, or third page?
It's the first page. First page of the story.
Okay. What I have in the first page, in the first column, I have got, okay, yeah, that's the first, okay. The main route for vehicle deliveries will be changed several times, impeding our daily business. Restriction on heavy deliveries and departure.
Yeah.
Okay.
Yeah.
So that has been the only way, because that's a temporary situation. This is only during construction. Is that correct, Mr. Davidson? That's my understanding there.
Um, um,
No,
This
that's my
is
understanding.
actually, I'm going to say no. It's not, because first columnist says the access from Harbour Road will no longer exist. So,
Yes, you will have access.
so on that basis, with the new layout, how are their heavy vehicles going to get in and out?
I don't know why Mr. I think you will still have access from Harbour Road.
No.
Yeah, you go exactly the same situation. You will come through Harbour Road, and then you can actually turn right, and then turn right again, and you're in the yard. You can have you.
I don't think that is correct, and there's certainly no certainty about it. I can my theories for Mr. Bathgate. In his own recognition, he says 485. I would expect any contractor's preference will be to maintain the existing access point and avoid, blah, blah, blah. The further says,
Time, Mr. Davidson.
pardon?
That's during construction time, and you're referring to the permanent situation.
Sorry, see, I accept that, actually. That's, yeah. I think there's I've raised that one too keenly, so, well, it's still, well, actually, it is still, but it brings us back to, with the design, with the new hammerhead, how do heavy vehicles get in and out and unload?
Are we dealing still with this document that's before us,
Yes.
Mr. Davison, or are we?
The access was always going to be, correct me if I'm wrong, Mrs. Suarez, but was the revised access not always going to be brought much closer, to where it is now?
No, the access to your yard, to the yard was always trying to take advantage of the existing road that you have got internally at the moment. And that's where we have taken we are taking the access from. But it can be access from both sides.
No, right. So
in addition to this, if I recall one of our latest conversations, you also mentioned that maybe Mr. Taylor required to move that access slightly, and we said we'll look into it. Okay, so that's where we are at the moment. But the access has been always the same location. And to reiterate that, I would like to say that I have asked almost in every meeting that I have been in for if that access point was not the most suitable, that they will please let us know, and we'll try to look something up.
Yeah, I think from one point of view, no access is suitable because they need a large yard. So that's the problem they have. But the point was, even on before it was rejigged after your meeting on the 24th of May 23, the access was basically on the south side of the ramp, the concreted ramp, so bringing it closer to the main premises.
I don't think I followed the question, Mr. Davison. Could you ask it again?
The original design of the new link road from Abercorn Street to Harbour Road always cut through Taylor and Fraser's yard.
Mm-hmm.
So the new access into their site was always going to be arranged on the southern side of where the current ramp access is from Harbour Road.
Where is the location good for the east-west link goes at the moment? And the access to the yard is exactly in the same location that the access road is now, because we consider that at that point, and we haven't been told any otherwise, that was the best possible location for Fraser.
So the access is effectively the same on both designs. What were you
I
saying?
don't understand why you're talking about both designs.
So I was wondering
You
if maybe
rejigged. Sorry.
Well, yeah. Sorry, Mr. McMurray.
Yes, sorry. I was just wondering, I'm struggling to follow exactly where Mr. Davison is talking about. So I was wondering whether there was a plan somewhere that was lodged that might actually help both Mr. Suarez, myself, and you just follow the line of question.
In terms of Mr. Davison, I think are you dealing with changes that have been made between a plan before this meeting and a plan following this meeting?
My understanding, correct me if I'm wrong, Mr. Suarez, is that following the meeting, you moved the road 2 meters to the north.
Yeah.
But did moving of that road impact upon where the new entrance into Taylor and Fraser's business would be?
Other than 2 meters further north,
Yes.
in terms of alignment.
So if what I'm trying to ascertain is, after you did the redesign, how did that take account of the fact that Taylor and Fraser were concerned about access and egress for their larger wagons?
We did exactly the same that before. We ran with the information that was provided. We ran, if the access was possible, we ran something called auto track. Colin will be, Mr. Batgate will be able to give you a much more detailed information. You basically have got a kind of like traffic model, the same, similar to the one that Mr. Taylor used to show the representation on site. So, and we ascertained that the road and the access was suitable.
I'll go to an easier one, I hope. If you could, in the third column, if you just go down 3, currently not enough adequate parking spaces, need to find alternative options. So what options were they? What was the results of your internal meetings to address Taylor and Fraser's concerns about that?
We in that meeting as well, I think it was a meeting that we had a first discussion about possible locations nearby. So we look at everything that we have in our possession. At that point, it was unclear what we have and if we could offer anything sensible. Later on during this process, because this is not something that takes 2 weeks to respond. So, and with further conversations with Mr. Taylor, we realized that we could offer for parking the area in Harbour Road, and we offer that. And lately, we have even in the last 2 or 3 days, as you know, we have even looked any further to try to see if we could have some alleviation of any issues during construction. I think we have kind of found a way forward, pending to Mr. Taylor approval, and I don't think we can I can't say anything else. We looked at
If you were kindly looking for alternative ways to assist with car parking, on what basis were you doing that?
what do you mean with that?
Why offer any other land or make any offer to look for land? Why did you make that offer?
Because it was the sensible thing to do, and because when you have go through a negotiation process with a landowner and a negotiation process that we have, as far as I am aware, has been discussions over the different elements that we can. What you look for is a kind of compromise and trying to find something that it can suit everyone. But that is just part of the
So
any kind of negotiation with anyone. You just try to find a way to eliminate any further problems in the future.
so there was an
Sometimes
acceptance.
you're successful, sometimes you're not.
Yeah, but would you say there was an acceptance then by the council that the yard did need the Taylor and Fraser did need other space?
No, that was not accepted.
Why were you looking?
Because I want very easy, because when you're looking for something else, what you're trying to look is to avoid a public local inquiry. So if during that process to avoid the public local inquiry requires that we can provide something, we will do so. But that with the royal approval. But that is part of the definition.
So did you ever say to Taylor and Fraser that you might find them a site if they dropped a potential objection?
No.
But if it went to a vesting date, they would get nothing.
I cannot say that. I cannot say things like that.
No, but sorry, you said that land would be offered to avoid today's meeting.
Yeah, if through a process of negotiation, through a process of Mr. Taylor said, look, if you it's just the normal process that you do with your negotiation. Your negotiation. I know at that point, and I still believe that the yard can work. That is a different matter. So what I will say is like that is the process of negotiation, and we look for something else in order to say, well, look, if we do that to you, is that suitable for you? Is that enough for you? That is what we're looking at. Different things.
But Mr. Fair would have been delighted had he known that you were, would have been delighted once you told him you were going to look for any extra land. But if that was only predicated on dropping an objection,
I don't put things. I never said that, and nobody has said that at any point. What I'm always saying, the only time they took the only thing that we say, look, if that helps you, we'll try to get it sorted for you. Nice as simple as that. Nothing to do with drop objections or anything like that. That is up to Mr. Taylor to decide, and I will never dream to say that to anyone.
I mean, correct me if I'm wrong, was there not a phrase to say it's normal during negotiations to do these things to avoid a PLI?
Well, you're trying to avoid an objection. You're trying to avoid a PLI, but that doesn't mean that Mr. Taylor can still put their objection if they want to. That is not what I said or anyone in the council said. By that matter, we only say we'll try to look for different things because we're trying to find a negotiation way that we don't need to go to a PLI. Simple as that. And I think that is what I have been doing with you during since you have been involved, Mr. Davison.
I'm confused by your answer because when I hear it, you said it was normal in negotiations like this to do things like that. I find them land to avoid a PLI.
It's normal to try to find common ground in trying to avoid an objection and a PLI. It's normal.
I think I think we've had the question, we've had the answer. Is
Mhm.
there, do you want to see this further, Mr. Davis?
No, I'll leave it.
Okay.
Next one down, right-hand column. At peak times of site returns, the existing space is at capacity, so it's already at capacity before it loses half of its space. The remaining land will not be adequate for the site accommodation. So
Just
one down from the one we've just discussed.
all right. So we're in the third column still, right?
No, yeah, in the third column, sorry, yes.
This is site accommodation storage area loss, right?
Is that the second? Is that the second line? Access to build.
It's the fifth from the top on the same page as the Harbour Road. The access from Harbour Road will no longer exist. So the first page of the document, or fifth row down, in the third column.
We actually discussed this as well during the meeting, and with Mr. McGill, because that was one of the main points. And what, if I remember well, what we said as well, it was that we couldn't see that happening, and how often was happening. I don't believe I have seen that when I have been on site, or it have been demonstrated to us. But notwithstanding this, we try to maximize the space with the new layout that gave them additional 2 additional meters to the north. So as much as we can, because that was the minimum requirement.
So it is an important point, but you never reverted to Mr. McGill or Mr. Taylor about it.
We never reverted. We introduced that into our design as much as we can.
That's fine.
I already say that, Mr. Davison.
If we go down to the second bottom one on page 1, first one says limitation of final remaining land and storage facilities. Second one, unable to move cabins with the HIAB due to physical limits of the space remaining. And the risk one, the truck HIAB is our only means of moving the accommodation.
Mr. Davis, just a couple of things. One, you've disappeared, so your camera may be off.
Lucky.
The other,
Sorry,
what is a HIAB?
It's basically a small truck with a crane on the back of it.
Right.
I had to Google it. So Mr. McGill here is highlighting, problems that would arise. So seemed quite important to me. So when did anyone go back to him and Mr. Taylor and discuss this?
You already answer that. We took into consideration that, so and the comment in our design, and we moved the alignment, trying to maximize the space that you have, that Mr. Taylor and Felicity has.
Mm-hmm.
We never went back to that. I already said that 3 times, Mr. Davis.
Right. So if I stop the questioning in this on the basis Mr. Suarez agrees that neither he nor Mr. Bathgate ever went back to Taylor and Fraser about any of these points after that meeting.
Formally, we never went back to them. Informally, through our design decision and in further meetings later on, we demonstrated that the concerns were taken into account in our design development.
But okay, you've confirmed that the final design was towards the end of May 23.
No, I said June.
Sorry, June. Thank you. It's June 23. And So that meeting was on the 24th of May.
Uh-huh.
The next entry on the statement of reasons is the publishing of a statement of reasons on the 14th. Sorry, the request for the Scottish Government to make the order on the 14th of September.
Correct.
So on that basis, somebody said no one ever went back, and there was no discussion with Taylor and Fraser about this, and they had no input into the revised design.
The input that they have was provided by this document. So we took into consideration their input and implemented that into our design. No, we never went further back because this is our design shows that is the absolute most feasible design and the only one that we could actually make.
It wasn't discussed with Taylor and Fraser, was it?
Well, at that point, no, it was discussed previously in the previous iteration, and then we took into consideration their comment to develop the next one and the final one.
So, I just don't understand, because in your summary precognition, you say that you've maintained an open dialogue with the objectors throughout the project.
Yes.
But if you aren't going back to them after they've given you 32 points and discussing it, how is that open dialogue?
Well, the open dialogue comes when every single request that you have in terms of information, in terms of discussions, in terms of meetings. I don't know, I go probably hundreds of emails that shows that we have been in conversation, and that's only my part. I don't even count the previous one. People ask questions on a regular basis. I reply to them as quickly as I can within the limits of my log work. And we have almost a finalized design, and we went to talk to Taylor and Fraser. They provided us information. We put that in our next stage of the design. That was the final design. The hindsight, which is a wonderful thing, maybe we should have gone back and say, if we have taken into consideration your comments for the next stage. And I cannot recall if we ever formally we didn't do that. I cannot recall if we do that in a conversation. That is as much as I can say.
But redesign, I understand, might have cost up to £1 million to pull the road back by 2 meters. Is that right?
£1 million? I don't think.
I think it's referred to in Mr. Bathgate's precognition, and
Is that to do with the culvert and crossing the
stream? That is not due to. If you can point that out for me, I will actually be able to understand that, because I don't.
No, it's fine. I'll leave it for Mr. Bathgate. Mr. Bathgate. After that meeting on the 24th of June 23, when's the next time you actually met with Taylor and Fraser on site?
Sorry? Can you repeat that, because I don't
hear you. After the meeting of the 24th of June 23, when is the next time you met with Mr. Taylor on site?
I think it was probably, I think you were present. That was the time that you were there. I think it was probably December. Is that possible?
Yeah, that's. I think it was the 19th of December. So
previously I have been in conversations with you.
Yeah, no, that's fine. And we walked around the yard And after your recognition, you were asked some questions, and you said that didn't agree with my summary of what had been discussed at the meeting, but only had just said that Sheila and Fraser were the most affected business.
In terms of land, yes.
In terms
In
of
terms of
land.
land, okay, which is a very, which is quite obvious.
Yes, yes, yes.
So it's no.
But those that meeting of the 19th of December 23, I followed up in an email to the council of, sorry, to the Scottish government, sorry, to, beg your pardon, to you and Victoria Willen, who jointly inspected the site, and I also referred to it in our objection letter to the Scottish government. I think that is number 8. I'll just check it. Sorry, TBF 8. Yeah.
Did we open that? Yeah. Or
Yeah. So,
do you,
well, on TBF 8 on page 2. So, yeah,
I haven't found it yet.
oh, sorry, take your time. So TBF 08.
It's not my hard copy, so that's why I'm trying to get this somewhere else.
I think it might be also CD7 or document 7.
It's our okay CD7.
Yes, that's at CD7.
Is that their column starts with Mr. Davison? Is that what you're referring to?
It's 10th of January 24.
Yeah.
12:55. Yeah. So on page 2, the 5th paragraph, I quote from the email that I sent to you in Victoria on the 21st of December. To offset the amount of any claim for loss of profit associated with the permanent loss of land required, my clients would ask the council to see if it has 1 acre of land it can sell to my clients to help mitigate their loss. The potential claim for loss of profit and increased overheads should reduce the nearer this is to the existing site. We discussed the site at Harbour Road, and you said you would investigate this. So, on what basis So if you never come back to tell me that there's no requirement to give any land at all, why were we? Why? Well, all I got from that email was a receipt of acknowledgement and a happy Christmas and New Year, because it was coming up to, which is perfectly fine, because it was coming up to that time. But why did I not get any? If that was wrong, then why was that not corrected?
The amount of any claim to. I don't understand the question, to be honest, Mr. Davidson. What you're asking me here.
See, the difficulty is you were the day-to-day base of the person that we met, and you're not a surveyor with CPO knowledge. So this is a compensation valuation matter, and it's never been answered. To the contrary, to suggest what I was saying was unreasonable. So I just don't see how we're here, in August the following year.
Where's your question, Mr. Davidson? I'm getting completely lost now.
Well, what I'm saying is, why did you offer to see if you could find a site of an acre?
Well, I will try to find a site of an acre, because that is what Mr. Taylor and Ferris as a business will be happy with. That's how you negotiate and how you try to solve problems. I'm really sorry, Mr. Davidson, but for me, it's nothing to do with compensation or anything like that. It's just trying to move the project forward and try to make everyone happy and trying to make some kind of agreement.
But with respect, it's everything to do with valuation and compensation.
Again, I don't see this being valuation, because the valuation will come after if we were able to find at any point a piece of land that we could offer to Taylor and Ferris, we will do so, and then the valuers and the lawyers will discuss how actually that process is. But first of all, I need to find something that is suitable. And in this case, so far, we haven't been able to find the 1 acre that it was required, according to Mr. Taylor.
So I had thought that Mr. Suarez had already sort of addressed this point, and to the extent that Mr. Davison was saying this is a matter related to valuation and compensation, to that extent it's not relevant to today's inquiry, but I thought the general proposition around why the council was looking at alternative sites and land had already been answered.
Yeah, I'm not quite sure. Was that what you were asking? Was that what the point you were pursuing, Davison?
The point I'm making is in July this year, we've been told there was never any need for alternative land. The business didn't need it. So I'm just trying to say, if that was the case, then why in December or in last year or in 2022 or 2023, whenever the case was being made for extra land and for the reason.
I understand you're coming from where you're coming from then, but I think you answered the question. I think you got an answer. And is there anything you're not satisfied with the answer?
Well, I'm just not sure how it answered why they were offering to look for an acre of land. It must.
Well, I think that has been answered, Mr. Davison.
To try and get agreement to avoid a PLI, is that the answer? One.
Yes. Nobody wants to be in this situation. Neither Mr. Taylor, I guess. Neither us.
But if something's going to be offered only as a special condition, i.e., so you waive your objection. That should be made clear.
Well, perhaps that can be. I mean, I think we've covered that point, Mr. Davison. I think if you want to make a submission on it, you can do that in your closing submissions.
Okay.
But I think as far as evidence goes, I think we've asked the questions about that, and we've got the council's answer to whether you think that's a suitable answer or not. I think that's something you can address in your submissions.
Okay.
Yeah, and sorry, we also have the evidence of Ms. Walker this morning, who also addressed at this point to an extent, which again we can cover off in closing submissions.
Mm-hmm.
And on the same page, again, this is quoted from the email of 21st of December. I fail to understand how the council can claim that it is trying to minimise the impact of the works on TNF's business and on the compensation. It is unfortunate that the council updated you before a meeting on the 19th of December. It was only then that my client and I were able to walk the council around the site and explain how the business operates, how the yard is absolutely crucial for the business. The council was able to see the amount of equipment that was on site on the 19th of December, and for the first time it understood this can increase considerably as business requirements dictate. It would have been difficult for the council not to accept the loss of such a large part of the yard will negatively impact upon the business, but it did so. So I followed that up in an email to you and Victoria Willen on the 23rd, and no one ever came back to me to say, I thanked you for acknowledging it, basically, and no one ever came back to say that was wrong. Are you now saying you never said that, or?
But that, as far as I can see, that is you respond to rulers from Transport Scotland that I was in charge of the CPO process at that point. I don't feel I was sweet. It will be within my gift to be able to answer that assertion from you. That's your comment. That's your but what I cannot do is basically to I don't think I should, not me at least, I shouldn't get an answer of that, because it's your conversation between you and Transport Scotland, which are the CPO. The CPO, I believe we have further. I don't know, because that is not my element, and that is not my remit. I believe there are further correspondent with that, but that is certainly not something I can answer. No, when it is between you and Transport Scotland as part of the CPO. That is just something for them to decide.
It was quoting from an email that had been sent to you and Victoria Willen of the 21st of December, so it was sent to you. Okay, I'll move on.
I think if you want pertinent emails, Mr. Davison, they really need to be in front of us.
It was you have to rely on the summary extracts in the TFB 8.
Mm-hmm.
Again, in terms of open dialogue and communication from our side, we thought from the council. I mentioned some examples in the discussion this morning, Ms. Walker. But on the issue that you were tasked with, which was getting a plan of the Excambian site, which had been originally made in 24th of May 23. It looks to be from Mr. Bathgate's summary that Mr. Bathgate's precognitions 3.1.2, Amy weren't actually instructed to prepare this plan until January 24.
Correct, because the Stambul land plan wasn't requested, or it wasn't. It was requested that we look at different options, and we went and did so. We looked for different land elements. We realized at some point as well that we probably could. We were the owners of the Farnborough Road Scambion land, if you want to call it that way. We also looked at the request of Mr. Taylor, and I think for possible satellite sites that we own, that we have never done before. We did all this work, and we basically came with the Scambion land. So we went to talk to you. I think it was in December, and when you were involved. And if once we got clarity from the register that we own the land, we took basically a month and a half to 2 months to prepare something for you, and we gave you that information in February 2024, I think. 2 months per that land. Once we have the required information, and
it was 7 months though from when it was asked for.
No, originally I was asked to look for different sites. The plan was requested in December. Well, that's 2 months.
I'm not certain that I think that contradicts the statement by Ms. Walker earlier on in her email, which I quoted from the email chain of 17th, 18th of July about the timescale for that.
But no, I don't have that in front of me.
That's fine. No. That's fine. Okay. 4.7 of your precognition, the initial selected route that was affecting the Taylor and Fraser Yard more significantly, was affecting the Taylor and Fraser Yard more significantly, and the project team realized that potentially could have a serious impact on the business. Therefore, we developed a route which minimized the impact on the yard and consequently on the business, utilizing areas not being utilized currently.
Yeah.
Right. So the initial route was prepared when?
The OBC actually gives you the 20 different routes that we consider. There are 3 within the OBC. There are 3 different options that explain where the routes were taken from. And that option, you will see that there is a drawing for each option, and then you will see that was. If I can open the OBC, I think I can remember where it was submitted. See if I can see that.
Just while Ms. Suarez is looking that up, could you tell me what document you're reading from, Ms. Davison?
That's Mr. Suarez's own recognition 4.7.
Okay.
The OBC document, basically whatever it is, I haven't have it got it here. Maybe here. Yep. That is final draft, 1st of June 2022. And within that, there is an appendix. That appendix is called route appraisal, and it gives you the different options considered. And at that point, that's basically the most logical option was cutting through the middle of Mr. Taylor, Taylor and Fraser land, and it was affecting some of the buildings. So that was not possible because that is one of the requirements that we have, not to affect the business and affect as little as possible the business premises. So we moved the road to as much as we could at that point to the north of Taylor and Fraser Yard. Probably Mr. Bathgate can actually explain that much better than me because I wasn't even involved at this point yet in the project. So my recollection is through reading all the documentation.
So on the 1st of June 22, you accepted that the design could have a serious impact upon the business.
No.
Well,
No.
sorry.
In the 1st of June 2022, we produced a report. That report includes an appendix that gives the different options, okay, of each option is of the layout of where each option will have pros and cons. One of them was that the most logical option, not taking forward at this moment, the most logical option was to put the road through the middle of Mr. Taylor's yard, through the middle. So that was decided through the process of elimination. And if you can read the OBC, and I will explain that to you, all the things considered, that was not a suitable option because we were impacting Mr. Taylor too much. So we moved to an area that the impact will be minimized, and that was to the north of the site. And that was in 2022, yes. But the final proposed alignment moved the proposed design to the north, eliminating the danger of impacting Mr. Taylor and Fraser buildings.
Yeah. What? So there was a design.
No, it was a design.
Sorry, an option.
Option.
Were there any options that avoided Taylor and Fraser's yard?
There was none, but they were considered. If you look at the OBC, they are considered and they are discounted for different reasons.
And would any one of them have had serious impacts upon the business?
You don't understand the question?
Well, so 4.7, you say the initial route that was affecting the TNF yard more significantly, and the project team realized that potentially could have a serious impact upon the business. Therefore, we developed a route which minimized the impact on the yard. So I'm trying to find out.
I will explain to you that basically when you go around 40 options in the OBC, explain, and the different routes that we're taking. The most suitable route, it was one that was impacting Mr. Taylor through the middle of his business. That is what that paragraph refers to. After that, we realized that cannot be possible. So we basically took an option that theoretically, and more than theoretically, there was no a straight line in terms of design. So we needed to do more additional work, but we didn't want to affect Mr. Taylor. We wanted to minimize the amount of land we were taking, and we wanted to minimize the impact in Mr. Taylor. So that is what in Mr. Taylor business. That is why we went to the north, and we choose the route that we choose. We choose as progressing in that basis. You go 40 options, you get down to 5, there are one that one was probably the one that was affecting Mr. Taylor much more. It was probably the most technically was easier to do. It was affecting Mr. Taylor greatly, so we just moved that out of the way. So we try to actually minimize as much as possible the impact of Mr. Taylor's business.
I think my difficulty is
One of the considerations during that is what at that point it was and one of the key requirements is we need to keep the business as they are, or as close as possible as they are.
I think my difficulty is that as far as Taylor and Fraser are concerned, all the options that took up their yard, they generally were on a line of the concrete ramp. Is that right?
No, completely right. It's 40 options, Mr. Davison. It's different options in different locations. It's how it has been developed is just between nodes. You look at every node in conjunction. So okay. I think I will advise you to read the OBC and then you could actually understand what.
Be above my pay grade reading the but the issue is, from my point of view, that the council had realised that was a serious impact upon the business by one of these options, and
by the preferred option.
Yeah, but the problem is by not going back to Taylor and Fraser for the final option, which no one discussed whether that would mitigate against the same issues that you were, trying to avoid.
Yeah, but the issue, Mr. Davison, is we cannot go with a non-finalized at least outline design until that is solved. What you go is an option, and then you realize that the option that you go a kind of like a specimen design. We call that in engineering terms. And then when you realize the specimen design that we want is that is the preferred option for different reasons. Okay, in our case, the chosen route was chosen not only in technical matters, it was much more to avoid the high impact in Taylor and Fraser. So we moved the road there, and we move into the next stage, and then we start to prepare the design, and then we can actually consult with the business. Yeah. Because if no, in that basis, it's impossible to progress the design. Yeah. You will need to consult 20 plus businesses, and we have done that. But before you can do that, you need to have something to show them, to explain to them what we're trying to do. You cannot go every engineer. It's technically impossible to go every single step back to everyone.
But you've always kindly accepted that Taylor and Fraser are the worst impacted.
Land-wise, yes.
Yeah, land-wise, right. My issue is why, when council was aware of the potentially adverse effect on the business, after the meeting in May 23, it didn't go back to Taylor and Fraser and say, does this resolve anything for you?
I didn't think your previous question is nothing. All right, okay. As I said before, we took into consideration the comments provided by Mr. Bagil. We put that in our design. We move our design to meter.
Yeah. Right, okay. Why did no one from the council actually...
Before you go on, do you have many more questions for Mr. Suarez? It being just past 4 o'clock now. Obviously, there's a question of, if you don't have many more, then whether we continue or whether we break and start again tomorrow.
No, I'm luckily for everyone to hear, I'm getting towards the end.
Right. So do you have an estimate of how much more time
Are there many questions?
I'm just wondering whether we should take a short break or.
Well, I
we'll be
prefer a
going-
5-minute break.
Okay, and so you're looking at going on till about 5 o'clock or so, are you? Or
Well, are we going to stop after this, or are we?
Well, I did say at the beginning of today that
No,
we would-
certainly
we would
I won't be till 5
normally
o'clock,
run
but I may
till-
have questions.
I said at the beginning of today that we may run till 4, that we'd normally run till 4 o'clock.
Yeah.
If you're going to be much longer, we'll need to think about whether it's convenient for everyone to stay till a bit later to when you complete it. If so, it might be sensible to take a short break, comfort break for everyone now. Do you think that you would be finished by? Do you have an estimate of how much longer?
I actually think I will be 5 to 10 minutes.
Right. Okay.
Oh.
So we'll just press on then. Yeah.
Why did it take until August this year before anyone in the council went round the yard to find out how it worked for the business?
Well, I don't know, because every meeting that I have been involved with, I have been asked the same question to Mr. Taylor and the representative from the first one in December when you were there. I said, well, you need to explain to us what are the issues. And as I said before, we took into consideration the issues that you put in this, Mr. McGill put in this 32 points. I was never explained as it was explained on August the 14th, which is completely different matter. I don't know why. Probably the only reason I can really say from my part is because we were never told.
Have you been involved in the relocation site, or is that like the Abercorn Street option?
And as far as I know is what we have been we've seen an email.
Would it be Ms. Walker that's been more?
You refer to the yard that we are looking for tenders. Are you referring to that one?
Yes.
I have seen that. I have seen the yard. Nothing else.
And in terms of alternative options for Taylor and Fraser, apart from the ones that were lodged today as additional option, are you aware of any other options for Taylor and Fraser in the area for equivalent space to replace what they're losing?
And no, I am not aware. As far as I know, that is as much as we have seen we have looked at every single option, and I don't see anything at the moment. Notwithstanding that doesn't mean that we are going to stop. That we will still keep trying to find something. If required, if we can have an agreement. I don't think that is ever has been under discussion. It's like we're still quite happy, like trying to find a way.
That's fine. Well, I think I can wrap it up there. Thank you very much, Mr. Suarez.
Thank you.
Thank you. A sec. I'll just check and see if I've got any questions. Just a sec. Okay. Just for clarity, I think there was this question, Mr. Suarez, of the reference to the site being unused in council's notes from previous meetings. What do you regard any part of the yard of Taylor and Fraser as unused at present?
That is a difficult question. There are elements towards the verge to the north. I have never seen anything there until our site visit. This be considered unused? Don't know. I can only answer what I have seen. I have never seen anything there until the 14th of August.
Okay. But for the rest of the site, you wouldn't regard it as unused?
Probably no. Underused, yes. Used, no. No, underused. So I'm gonna rephrase that again. It's probably used, not often, I would say. The elements of the yard. From my point of view, I think the yard could be maybe used more efficiently.
Mm-hmm. Right. We did look at the list of actions from the Mr. McGill's list. This is I think we called it TBF 30. Am I right? Yeah. Okay. Could you? I don't know how long it would take. Mr. Davison asked you questions about a number of items on those lists. Are those all the items in respect to which you made changes to the design, or were there any other matters in respect to which you made changes to the design that have not been brought up in Mr. Davison's questions, or that you haven't mentioned in response to Mr. Davison's questions?
No, I think it's okay. I think there are issues in that list that there are some assumptions from Mr. McGill that we haven't considered things, and we have already considered that when we were preparing when we presented to them the design. For example, there are issues about drainage that, as I mentioned before. These issues were already taken into account, so we didn't need to do anything because they were part of the design. Because that's what I will expect by aiming, because they are professional and they do design these things all the time. So there are quite a few elements that within that list that they were already part of the design. We didn't need to do anything else, to be completely honest.
Okay. Yeah, just in terms of the site inspection, you said that you found out matters at the site inspection on the 14th of August that you hadn't previously been aware of. Can you just say what it was that you found out that you didn't know previously?
How basically their working practice has not been actually explained to us how they actually work. No, within things I have been involved. Before that, I cannot find any records of that. So and for me, the working practices, the issues that they seem to have, explained by the site manager, they were never highlighted to us. I think probably Colin will be able to Mr. Parkgate will be able to actually expand on this much more. But I recall that every single time I have asked for that kind of information, and to be completely fair, it's more than welcome that we can see that now, but it was plenty of opportunities before to be able to do so. And as far as I remember, and as far in my notes, never seen that in black and white as explained it was at that day, and been asking for that information for this kind of one more. Inability.
So, okay. So it's in a position essentially you'd asked for information on how Taylor and Fraser operated, and you hadn't received it. That's your position.
The position will be we have made assessments with the information that they have provided, like the 32 point, for example, like the issue with the high ups and all this kind of stuff. We may assign, we consider that in our design. We move the design. We make sure that it's enough space to actually maneuver the equipment on site, and specifically the big HIVs and the case that they were 2 or 3 at the same time, and that was the first time for me. So, and that it's significant. And what we have been asking is for the working procedure, and we've never been able to see that until August.
Yeah, had you or any other member of the team asked Taylor and Fraser to show you around the site and explain their operations?
We have been around the site, and we have never received the same explanation at the 14th of August.
Okay, right. Well, that's all the questions I have, but perhaps Mr. McMurray has some further questions for you.
No, sir, I have no further questions for Mr. Suarez.
Brilliant. Okay, well, thank you very much, Mr. Suarez. And that concludes our. I don't think we can take any more witnesses today. So that leaves Mr. Bathgate, Mr. Davison, and Mr. Taylor for tomorrow. Just in terms of giving Mr. Taylor certainty about when he'll be called, should we change the order and take Mr. Taylor first thing tomorrow? Would that be suitable? Mr. McMurray, would it affect how you deal with your case?
I don't have any objection to that, but if it helps Mr. Taylor have some certainty around availability, we can certainly work with that.
Would that be suitable for you, Mr. Taylor, Mr. Davison, or Mr. Davison?
Fine with me. Mr. Taylor, you need to put your microphone on.
How's that?
Yes, that's great.
Thank you.
Apologies. I'm okay with whatever it would suit you all. But I mean, I've actually was hoping to do something else this afternoon, but I've actually found the whole thing quite riveting. I'm quite totally new to this type of inquiry, so that's it. No, I'm delighted to be first thing or whatever. Just let me know what's best.
Okay. Well, Mr. Davison, it's really up to, I think, if you're content to take Mr. Bathgate first and then Mr. Taylor after that.
Right. Are you going to be attending tomorrow anyway, Mr. Taylor, because you find everything riveting? Because if you are, it's probably not.
Sorry, the whole thing is very important to the company, and I want to give it full attention. So but I would just delighted to attend when it's suitable to you all.
Did you want to go first?
Sorry?
Do you want to go first, or do you want Mr.
Well,
Bathgate to go first?
let Mr. Bathgate go first, and I'll follow that. Okay.
Right, thank you.
We won't make a change to normal order. Thank you, Mr. Taylor. And so we'll meet again tomorrow. Should we meet same time or a little bit earlier? Perhaps 10 o'clock is convenient to everyone.
Okay.
Yes, when you're happy with that, we'd be happy to start half an hour earlier if that works for everyone. But equally, if 10 o'clock is better, then we're happy to stick with that.
Well, we'll stick with 10 o'clock then. Okay.
Thank you very much. Thank you.
Thank you, everyone.
Thank you.
We'll see you tomorrow. Good night.
Thank you.